the part of respondent in settlement of ferry service.
Motion.
My lord,
When do you want?
tomorrow, my lord.
Tomorrow?
My oblige.
Lordship, I mentioned item 5 of today's list.
Yes.
Lordship, I'm appearing on behalf of Mr. A. Fupan. Lordship, he has some difficulty. He is not well, Lordship. I've informed the other side.
Okay. When do you want?
Lordship, anytime next week. Only
Okay. On a request made on behalf of Sri A. Fukan, Learned Standing Council GAD, matter is adjourned to be listed on the 3rd of August, 3/8.
My lord, I beg to mention item number 11, my lord.
Yes,
This matter may be listed on Friday, my lord.
Friday, you have some difficulty today.
Yes, my lord.
On a request made by Ms. S.B. Chaudhary, Learned Counsel for the petitioner, matter is adjourned to be listed on Friday, date. PNRD, you have informed.
I have not informed.
Oh,
my
if you
lord.
do not inform, how do you
Covenant is
mention?
there. Covenant is there, my lord.
If PNRD is there, PNRD, they have got a different council. Don't make a mention. You wait for your turn.
Yes,
Don't make mention without informing.
We have the consent of professor, Lordship, I beg to mention number 16.
1/6. Yes. On a request made by Sri S.S. Roy Learned CGC. Matter is adjourned to be listed after 2 weeks. We give a date list on today's 28th. We'll have it on 10th of August,
Lordship, let it be on 19th.
19th. Why so long? Why do you need so much of time?
Lordship, because I will be out of station. Lordship.
List on 19. Have you filed the affidavit?
Yes.
19/8. Yeah, interim order passed earlier to continue till the next date of listing.
Lordship, with the consent of the respective process, I beg to mention item numbers 22 to 25.
Yes.
May this be taken up on Friday, my lord? There's some difficulty in some.
Okay. Item numbers 22 to 25. On a request made by Sri N. Barua, Learned Standing Council,
Yes,
IOC,
I was.
matters are adjourned to be listed on Friday next. Friday.
There are interim orders in the matter now.
Interim order passed earlier, stands extended till the next date of listing.
Deeply obliged.
I beg to mention for listing.
22 to 25.
IA, my lord. For listing, my lord. For IA, my lord.
IA,
Day after tomorrow, my lord.
when did you file? Have you filed?
Yes, my lord. Number is
Okay.
day after tomorrow.
IA for
IA for stay.
stay,
Yes, my lord.
The private item number 14, my lord.
1/4.
Yes.
Yes.
I will take my lord 1/3 of August, my lord. I have to take now instructions from client.
What is the matter about APDCL?
That APDC.
APDCL you have informed. You have not informed the APDCL. You inform the APDCL. Don't make a mention without informing. Yes.
May I please, Your Lordship? I beg to mention item number 15, Lordship.
Item number
15, Lordship.
15.
Due to some personal difficulty, Lordship, with consent of the already respondent, the matter may be taken up next week any day, Lordship.
Okay. On a request made by Sri ABT Hawk, Learned Counsel for the petitioners, matter is adjourned to be listed on 5th of August.
Obliged.
Question of the respondent that I beg to mention item number 12, lordship.
Yes.
Conducting counsel is out of.
Okay. On a request made on behalf of Sri O.P. Bhatti, Learned Counsel for the petitioner, matter is adjourned to be listed on 14th of August. 14/8. Is there any interim order? No.
Item 26. Supplementary system.
PWD? Public Works Department? Yes, what are these?
My lord.
matters?
My lord, my case is that, my lord, the petitioner is a registered, my lord, contractor as well as having the trade license to carry out, my lord, the maintenance works in regarding the maintenance of the various buildings of the offices as well as the, my lord, bungalows or the, my lord, residential apartment of the honorable ministers of the state of Assam, my lord. And accordingly, my lord, I have been offered with a preliminary work order for the, my lord, at page number 27, annexure 3. My lord, may kindly have a look, my lord.
Date,
Page 27, annexure
date.
my lord, 29/3/2025, my lord. With a condition.
Hmm.
With a condition that, my lord, however, the work order will be issued on receipt. Your tender for the above mentioned work has been selected for acceptance at your own quoted rate. You are hereby informed that the formal work order will be issued on receipt of the administrative approval from government, and necessary formalities such as signing of the tender agreement will be observed accordingly. However, you are allowed to proceed with the work immediately in consultation with the AE PWD Dispute Territorial Building Subdivision Gauhati 6 and complete the same without fail, my lord. So, my lord, in accordance with this preliminary work order, I have been, my lord, continuing with my work, and within the time limit, my lord, I have also finished, and till date, my lord, I am maintaining the office, my lord. And that, my lord, can verify from annexure 4, my lord, that this has been issued on 1st of April 2026, my lord, wherein I have page number, my lord, 28. 28, my lord. This is a document, my lord, by which I have been allowed with my man and other mercenaries to enter into the, my lord, specified premises and, my lord, carry out the works. Now, my lord, the difficulty is that till date, my lord, that administrative approval and, my lord, the other necessity which is required, they have not issued to me, my lord. That is my main set of grievance, my lord. And on the other hand, my lord, they are contemplating me to, my lord, oust me and wanted to replace with, my lord, another such type of, my lord, company, my lord, without assigning any reason thereof. We have stated in details, my lord, in our petition as a pleaded case, my lord. So therefore, my lord, this is an arbitrary act on the part of the respondents, my lord. On the other one hand, they have, my lord, employed my, my lord, man, including me, my lord, but they have not neither released any fund nor the administrative approval or the work order had been extended, my lord. That is the basic case, my lord. Lord, I have stated in paragraph 7, my lord. My lord, may kindly at page 11, my lord. So, my lord, they have promised that the, my lord, once the preliminary work order had been issued, my lord, that the other requirement will be done.
What is the relief you are seeking?
My lord, the relief, basically, I am seeking that.
We were worried about cost title going to 7 pages, 8 pages. Now we are confronted with relief going for 6 pages.
Lord, the prayer portion, my lord.
6 pages relief you want.
My lord, the prayer.
What do you actually want? Tell us.
Prayer, my lord, the relief mainly, my lord, I am praying for relief F, my lord, relief F.
But where is the, what is the basis of your apprehension? There
My
is
lord,
no
the basis
order.
of my apprehension, my lord, is that it is going to happen by today or tomorrow, my lord.
Yes, Mr.
My lord, my lord.
Yeah.
The apprehension hasn't even happened yet. It's either day or tomorrow.
No, apprehension is not on happening. Apprehension is before happening.
My lord.
Is there any move to cancel?
Regarding this, I'll have to obtain my instructions.
Don't cancel.
My lord.
Take instructions, don't cancel. We'll have this on Monday or Friday, if you say on Friday,
My lord.
if you are able to get the instructions, otherwise on Monday. Okay? Monday. Don't cancel now, okay? Why all these cases, Mr.
My lord, different preliminary work orders, one for the minister's bungalow, one for the, my lord, this Lok Sabha Bhavan, my lord, that Janata Bhavan earlier, my lord.
At our left.
My lord.
Third, Sri A.R. Bhuya, Learned Senior Counsel assisted by Sri N.A. Madhur Bhuya.
My lord.
For the petitioners, full stop. The grievance of the petitioners are similar. Full stop. They claim to have been issued preliminary work orders for maintenance of certain structures
Mal.
pertaining to the minister's bungalow and official buildings,
Mal.
with the condition that final orders would be passed after administrative approval.
Building question.
Full stop. While the petitioners were allowed to continue, even after more than passing of a year,
Month.
the administrative approval has not come, full stop. The petitioners also apprehend that they will be replaced
Month.
by another set of persons.
Month.
Mr. Para. Let the instructions be obtained by Sri M. Bhuya, Standing Council, Learned Council appearing on instruction of Sri B. Gogoi, Learned AG for the PWD on the aspect of the apprehension. Full stop. Let these matters be listed for motion on, we'll have it on a Monday, on 3rd of August, 2026. Till then, to balancing the equities, it is directed that till then status quo as on today
Malum.
with regard to the work orders be maintained.
Oblige.
Let
Yes,
to
Mr. Right.
facilitate
Malum.
the learned
It is,
council
it
for
is.
the PWD
Scan
to
copy to the-
obtain the instructions, that extra copies be served
Malum.
upon him during the course of the day.
Malum. Oblige, deeply oblige.
That I order. No?
Yeah, yeah.
Lordship, the issue pending in this matter is currently sub judice before the Honorable Supreme Court. This case was filed for non-disbursement of the subsidy. Subsequent to filing of the writ petition, the principal amount was disbursed, but the claim of interest for delay is pending, Lordship. This Honorable High Court in the division bench has held that for delay cost, interest is liable to be paid. Against that, SLP, the state government and Union of India has filed SLP, which is pending, Lordship. So may I pray that till then this matter may be kept pending. Lordship.
Okay. Dr. A to D, learned counsel for the petitioner has submitted.
Lordship, Lordship, with regard to the subsidy amount that has already been paid pursuant to the Lordship direction of this honorable court. In the earlier round of litigation, Lordship, there was no specific order for payment of Lordship interest. In my respectful submission, Lordship, in fact, this litigation is marked by raised judicata. But already we have paid the subsidy amount.
Adjudicata, what was it adjudicated?
Yes, Lordship, adjudicated. Lordship, if Lordship goes to the order dated
Page?
Lordship, in the petition, the particular portion of the order, Lordship, find it says it start from Lordship, page 30, Lordship.
30.
31, yes.
What was the relief paid for in that case?
Lordship, they were agreed by non-payment of 15% of CCSI. Lordship, that was recommended by the state level Lordship committee.
Okay.
Lordship, may I just take your Lordship to page number 33 would be the operating portion. Page 33. The order starts from page 31, Lordship.
Yes, we have seen, but let us see the.
Yes, Lordship, page 33, Lordship. Just para 5 I'm reading, thereafter para 6, Lordship. Petitioner applied for registration under Central Capital Investment Subsidy Scheme 1997. General Manager, District Industry and Commerce Center, informed the petitioner by letter dated 12/7/2005 that it was registered under 1997 scheme. Petitioner also requested to submit its claim in the prescribed form. Accordingly, the petitioner submits its claim in standard form, furnishing all necessary details as required by notification dated 1988. General Manager, District Industry and Commerce Center thereafter forwarded the claim of the petitioner to the Director of Industries and Commerce, Assam, to be placed before state level committee. It is stated that the case of the petitioner was duly inquired into by the concerned manager as per inquiry report. Admissible amount of investment in the plant and machinery of the petitioner comes to 96 lakh 61,706. And on the aforesaid basis, 15% of CCSI recommended to the petitioner work out at 14,79,256. Then just the first para 16, paragraph 6, I'm reading. According to the petitioner, the state level committee meeting held on 4/12/2007 had approved the claim of the petitioner to 15% CCSI amounting to 14,79,256. And Lordship may kindly take to the operative portion of the order, there is a page number. 42, Lordship.
Say, Mr. Das, this judgment was the subject matter of challenge in a writ appeal.
Lordship,
This judgment was the subject matter of challenge in a writ appeal.
no, Lordship, this was not challenged, Your Honor. In fact,
What is the judgment at page 43?
page 43.
Lordship, this judgment was challenged by state government in appeal.
Exactly.
Lordship, appeal because they were not given the right to file their affidavit. That's why, Lordship.
Nonetheless, you said no. Why have you said no?
Lordship, I thought that the appeal regarding the Supreme Court.
No, Supreme Court. This was writ appeal, we have said.
Read appeal, it was challenged.
Writ appeal, then writ appellate court remanded the matter.
Yes.
So why didn't you come to the remand order? There has been development. You are reading the initial order.
Yes.
It was interfered with by the division bench.
This was a main order based on which, Lordship, the central subsidy was approved.
Understood, but what is the subsequent order? What is the subsequent order?
Subsequent order, Lordship, then Lordship, the state went on an appeal, Lordship.
That we have seen.
And thereafter, Lordship, page 48, Lordship, subsequent order, wherein the petition was disposed of, Lordship, the direction. Lordship will find page number 50, it starts from page 48.
Then there was a further appeal by the,
Yes, but they, Your Honor, did not succeed in the appeal, and thereafter, Lordship, the amount was, Lordship, paid by the state. Thereafter, Lordship, the state level committee was constituted a meeting, and accordingly they approved the amount of 14 lakhs, and accordingly fund was given to NITFI, and we have disbursed the amount. In this series of litigation, Lordship, there is nothing like, Lordship, the cost which the petitioner is claiming, Lordship, regarding delayed payment in the matter of subsidy.
what, you have not made the prayer in the earlier
So,
petition.
Lordship, there is
It has gone through adjudication process, division bench, again remand, again
Lordship,
division
issue is-
bench.
issue is slightly different, may I submit, Lordship? The first writ petition was filed because there were two schemes. We had applied under two schemes, and
Now,
because
what is pending before the Supreme Court?
the issue of grant of interest, whether it is liable to be paid for delay. The question of res judicata does not arise, Lordship, because the earlier issue was that since I was entitled and disbursed amount in another scheme, whether I would also be entitled under the present scheme.
Okay, let
So that was decided,
the
Lordship.
decision come from the Supreme.
Subsequently, Lordship, when
Let the decision come from the Supreme Court.
Yes,
If the
Lordship.
Supreme Court decides
because
against
even
you,
after,
there will be no case for adjudication. If it decides in favor of you, then we can consider Mr. Das's.
yes, Lordship,
Okay.
because even after the
It is joint, heard Dr. A to D. Learned counsel for the petition also heard Ms. U Das, Learned State Counsel, and Sri S. Das, G. Das, Learned Counsel representing the NITFI. Footstop. In the also heard, heard Dr. A to D, Learned Counsel for petition, also heard Ms. U Das, Learned State Counsel, full stop. You are from some. Again, again, you are Bormon, M. Bormon. M. Bormon on behalf of again, CGC. Also heard Sri G. Das, Learned Counsel appearing for NITFI, who however has submitted that the present application is barred by the principles of res judicata. He has submitted that the issue was decided by this court and affirmed by the division bench. No, that the principal issue was decided by this court and affirmed by the division bench. And there was no issue raised by the petitioner with regard to interest on delayed payment. What's the para? It however transpires that the issue regarding payment of interest on delayed payment, regarding interest on delayed payment is presently pending before the Honorable Supreme Court. Full stop. This court is of the opinion that the decision to be taken by the Honorable Supreme Court would have a bearing, material bearing in the adjudication of the present case. Para? In view of the above, the matter is adjourned by a month. Full stop. The parties, the learned counsel for the parties would be at liberty to make a mention as and when there is any decision of the Honorable Supreme Court.
SLP 1105.
In Supreme Court, the report in SLP 11656.
056 now.
11056
of
public
2020.
2020. Okay. Should we have a date, Mr. Dr. Trudy?
Not yet, Lordship.
No, should we give a date? List on, we give a date, let us.
Lordship,
We-
presently, I think Supreme Court matter won't be taken up. Because it's,
Why?
no date has been given till now.
No, we give a date
Maybe in Lordship in December.
on December, 2 months, 2 months. List in the last week of September.
Apply.
Respondent number 2 is still there in this world. Respondent number 2 is still there in the world.
Still there in the,
World, this world.
he's alive.
Yes.
Was there any attempt to remove him? No attempt,
We have no intention to.
no intention. Don't make that intention. Don't have that intention. Yes,
What's the page 89, last paragraph.
what is this? Labor code.
Labor code.
Do we take this for the final disposal?
Lordship.
If you are ready, both of you, amicus?
Lordship, page 89, last paragraph.
146023. Page
Page 89.
89. You are the management,
Yes, I'm the man.
89.
Second paragraph. In view of the above discussion, I am of the judicious view that the management company was not justified in terminating the served the applicant worker. It has been already held in the aforesaid discussion. The workman had already attained the age of superannuation at the time of release on 17/5/2019 from the service of the management company, and as such, the management company cannot be asked to reinstate him.
It's a small
Yes, sir.
issue, 2 months salary.
Lordship, I am not on the salary, Lordship. But may please to see how the trial court finding of the land and labor court, Lordship. Under the facts and circumstances of the case, I hold that the workman is entitled to 2 months salary, full salary, in same rate at the time of release. The management is directed to pay full wage for the period from 1/5/2019 to 17/5/2019 and 2 months salary. It is made clear that 1 month pay that has been given by the management to the workman in lieu of the notice cannot be deducted from said 2 month full wage of the workman applicant. He is also entitled to get lump sum of rupees 10,000. Lordship, I want to clarify, Lordship, we are not after the money, Lordship.
Just a minute, please. We had heard you for some.
Yes,
moment.
Lordship.
We're trying to have the note.
Last Monday, Last Monday, It was on the last Monday probably. Eleven plus 11, 11, 8 plus 11. Probably it was on 11/8 lots.
Hmm.
No, just click. Oh, 11/7. 11/7 lots.
No, no, we was trying for the little note if we had. We don't have the note. You have to tell us the facts. Yes,
Lots.
we don't retain the, have
The
not
direction of
retained
the trial court, labor court case.
it. Hmm?
Lots if there are two, by
You
submission,
give us the facts in,
lots of
brief.
the respondent number 2 was engaged as a consultant in the firm of the petitioner lots.
Was appointed as consultant.
Lots of.
When was it done?
Lots.
When was it done?
It is there lots. Page. What was it? 148. Page 80 lots.
80.
80. The applicant has joined the duties of the management above on the request on 1/4/2018.
1/4/18. Okay. You can have a seat, gentlemen, don't stand. There are seats vacant. Ask him to sit.
That's it.
No, ask him to sit. Yes,
Then let's see, on 1/5/2019.
1/5/19,
Let's see, he was
What?
released from the service.
released.
Yes.
It was a consultant was for how many, what was the tenure?
Let's see, up to date of release, he was paid all his dues. Lots.
No, was it for a particular tenure?
No lots. Yeah. There was, it was there.
His appointment, engagement, whatever you say,
Lots.
was it for a particular tenure? Okay, doesn't matter. Then what had happened?
Let's see, thereafter on 1/5/2019, he was released from service.
Released.
Lots. Thereafter, he filed an application under section 2S before that labor court laws. Containing that, let's see, annexure 1,
Page?
page 20.
He approached the assistant labor commissioner
Lots.
for raising a reference.
No, directly under section 2S before that labor court laws.
No, but this is for the assistant labor commissioner.
No, let's see, that was not entertained. Thereafter, let's see, page 25. Yeah, page 25 is our application. Page 16 lots.
16.
Lots.
Sixteen is an application under 2A,
2A,
2 capital A,
2 capital A,
by the individual workman.
by the workman. In this case, his prayer was that he should be reinstated because he was illegally terminated.
Okay, then what had happened?
Thereafter, we file written statement.
You filed written statement.
Page 25.
petitioner, applicant,
Lots,
management, file, WS.
lots.
Where is the WS?
Page 25.
25. Okay. Thereafter,
That lordship, the award was passed.
no,
We led evidence.
you led evidence.
Yes, sir. Both.
And the petitioner, both the parties led evidence.
Lordship. We went across of both the workmen as well as the management.
Evidence adduced by both parties. Thereafter,
Thereafter, award was passed on 28/7/2022,
page
page 79.
79.
Lots.
Twenty-eight, 7,
Page
2022. Award,
28/7/2022.
yes,
Award was passed.
by Labor Code
Labor
Gauhati.
Code, Gauhati.
Thereafter,
Lordship, thereafter we approach this honorable
now
court.
what is the award?
Award is page 80, operative part is at page 89.
Page 89.
Lots. In view of the above discussion, I am of the judicious view that the management company was not justified in terminating the service of the applicant worker. It has been already held that the said for the discussion, the workman has already attained the age of superannuation at the time of release, that is 17/5/2019, from the service of the management company. As such, the management company cannot ask to reinstate the workman. Under the facts and circumstances of the case, I hold that the workman is entitled to 2 month full salary in same rate at the time of his release. The management is directed to pay full wage for the period from 1/5/2019 to 17/5/2019 and 2 month salary. It is made clear that 1 month pay that has been given by the management to the workman in lieu of notice cannot be deducted from the said 2 months full wage of the workman. He is also entitled to get a lump sum of rupees 10,000 in interest cost. What's my submission?
Just a minute. The management is directed to release for the period 15/19 to 19. Okay, you tell us.
What's the page 77?
77.
Lots.
Yes.
What's it? This is a release letter dated 34/2019. And dear R.S. Kalita, we are hereby informed that we are releasing you from the job with effect from 1/5/2019. We are giving 1 month salary, extra salary in lieu of 1 month notice period by check number so and so and amount to be so and so at Axis Bank Gauhati. Your full and final settlement has been completed. Wish you all the best. Then let's say below receive, there is authorized signature of the company. Then received by the so-called workman, R.S. Kalita. There is no date, but page 68. this is-
68.
Yes. It was submitted by the workman before the trial, before the labor court. also. Everything is same, but there is a extra date has been put 17/5/2019.
Yes,
Now, let's see, when the labor court come to conclusion that he is attained the age of superannuation on 1/5/2019
on,
on 30th of April 2019.
but the Labor Court has said that 17/5/2019.
Lordship, that is a lordship of Learned Labor Court come to a conclusion after perusing this letter that there is a date of 17/5. Lordship, please to see our.
Where are your records? Records?
We have annexed everything.
No, this letter, if you say that the copy placed by the workman before the
Yes, sir.
Labor Court bears a date,
Yes,
whereas your copy does not bear a date of receipt.
yes, Lordship, this is
We
the,
may have the records.
yes.
Origi-
Only photocopy.
No, photocopy, those are present.
Even that letter was not exhibited. It is on the, in the award. We could not place the original to the labor court also. Only Xerox copy was placed. Part of the award.
So, but is it a fact that he was serving till 17/5/19?
No, Lordship, he was released on 30th of April 2019 from 1/5/2019. That is confirmed the learned labor court also.
Then what does this mean, that this release letter was received by him on 17/5/19?
Lordship, that is the history, Lordship. There is no record to that effect also. Only Lordship, please see the finding of the learned labor court.
Then we have to go by the evidence which has been
Yes, sir.
adduced.
Lord-
What have you stated?
Lordship. Proceed page 72. Page
Page?
72. Page 72, WW1, Sri Rameshwar Kalita,
Yes, which one?
page 72.
72. 72. What is 72?
Is a cross of so-called workman law. I have not deposed the fact in my evidence in chief as stated in the claim petition. It is not a fact that I do not fall under category of workmen, as I draw a monthly salary of more than 10,000 as provided in section 2S4 in my evidence in chief on affidavit. I have not submitted any age proof document. In the verification before the labor court, I have stated that my age is 60 plus. I do not know whether 60 years of age is the superannuation age in management company. Before my reinstatement, the management company paid me 1 month salary in lieu of the notice. It is not fact that I have not mentioned anything about Exhibit A in the claim petition as well as in my evidence in chief. It is a fact that Exhibit A is only salary package statement for 12 months. It is in this case, the director and managing director of the management company are not party to the case. In other words, I have not claimed anything in my claim petition against the director or the engineer director of the management company. It is not a fact that I was released on 17/5/2019.
He says that. Perhaps he said he wanted to say something. It is not a fact that,
It is not a fact that I was released on 17/5/2019.
here's an admission.
Claiming to be in service after 75 also.
Lordship, the
No,
entire-
it doesn't mean that. It might mean, it may have two meanings. That even after 17.5, he continues to be in service, or he was released prior to 17.5.
That's a finding of
On
the-
17.5, he was not released.
Yes. And Lordship, the entire award is on the surmises and surmises, Lordship. Then it is not a fact that my claim petition, the claim petition is not tenable as I cross the age of limit of superannuation. And hence the management company reinstated me at the age of
So, Mr.
superannuation.
Kyle, what is your case? That you had released him, why this release letter of 34/2017 with effect from 1st of May?
May.
So 34 is the, 31st of April is the last,
30th of April is the last day.
April, 30th of April is the last date of his service. And you had accordingly given 1 month salary in lieu of the notice. So there is no illegality on your part.
This is my submission.
The learned labor court has said that till 17th he is entitled to the salary, number one. Then he is entitled to 2 months
2 months
salary.
salary.
And then you can adjust the notice period.
Not to be adjusted.
He said adjusted.
In addition.
Is it?
Yes,
Sir.
Lordship. The management is directed to pay full wage for the period from 1/5/2019 and 2 months salary. It is made clear that 1 month pay and that has been given by the management to the workman in lieu of the notice cannot be deducted from 2 months salary, full wage salary.
No, this 2 months, where does it come from?
That is, Lordship, I also not understand why labor court has awarded.
No, see, even for the period, worst case for you,
Lordship,
that 1/5/19 to 17/5 he might get,
Lordship,
if we assume that the date is correct.
Lordship.
But these 2 months,
Lordship, 2 months, Lordship, when the labor court come to finding that on particular day he is attained the age of superannuation, whether court has any power to award.
no, from where does it 2 months come?
That is the Lordship a mystery, Lordship, for me also.
No, from where the deduction, he has come to a conclusion that he is entitled to 2 months salary.
There is no finding to that effect also. Lordship, please to see finding with respect to the.
He is also not saying that he did not attain the age of superannuation. He also only says the release letter is of 17th. So I am entitled to 17th. So these 2 months, where does it come from?
Lordship,
Was an issue framed by the Learned Labor
Lordship,
Court.
page 82.
It's a two-way application. So issue has to be framed by the
Yes.
Learned Court.
Lord.
It's not a reference.
Lordship,
Issues are friend.
page 82.
Issues are friend.
Page 82.
Lordship.
82 years.
Upon pleading of the parties, filing issues are framed, following issues to be framed by my learned predecessor. 1, whether the case is maintainable or not. 2, whether the case is weighed for non-gender of necessary party. 3, whether the applicant falls under the category of workman, whether the workman attained completed age of superannuation. Number 5, whether the management, Mr. Khandelwal Sawmill, is justified in terminating the service of the workman, the Rameshwar Kalita. If not, what relief are entitled to the workman? Then Lordship make the finding with.
4 has been answered in the affirmative. That means what? 4 is whether the workman completed the age of superannuation. Yes, he had
Yeah.
completed.
Yes,
So if he has completed, so this 2 months, I think it's arbitrarily given.
yes, Lordship. This is my humble submission.
Okay.
And this for 17 days, what will he get?
Lordship, about 25,000.
25,000. Have you paid this amount?
No.
Okay.
Yes.
And this litigation 10,000.
And he.
Are you aggrieved by this litigation cost?
Lordship, I have in my submission, we are not about the monetary part. we are questioning the legality and validity of the order passed by, the award passed by the landed.
Then we can do one thing without giving Mr. Chakraborty much burden. We can hold that 2 months salary, there is no basis.
Lots.
And 17 we assume, we will not say yes. We give benefit of doubt till 17th. You calculate pay till 17th and 10,000 will not interfere.
Lots.
Anything you would like to?
I would like to add something, Lordship. Lordship, may peruse page 19.
Don't make it complicated.
No, Lordship.
We have come to a tentative conclusion.
Page 19.
19, page 19.
19. This is a release order, Lordship.
35,
19 also, Lordship. 19.
34.
34, Lordship. Lordship, may I read? Dear
Please.
Mr. R.S. Korita, we are hereby informing that we are releasing you from the job with effect from 1/5/19. We are giving you 1 month's extra salary in lieu of 1 month's notice. A period white check number such and such, dated such and such. Lordship, from this release order, it would appear that is not a letter releasing the person on attaining the age of superannuation.
It's prior to that,
Prior to that,
because there is no question of notice.
notice pay.
Will not come.
Per se, it's a retrenchment.
Retrenchment. Right.
Retrenchment. What happened after that, against this retrenchment or termination, the respondent number 2, he approached the ASL Labour Commissioner, raising the industrial dispute, Lordship. That is page 20, Lordship.
Yes, we have seen that.
Lordship, may peruse page 22. Page 20 is a verification, Lordship.
22 years.
Here, Lordship, in the verification, Lordship, the respondent number 2 put his age as 60. From this document, Lordship, the petitioner before this honorable court coined the idea of retirement, Lordship. They have taken this verification, and from this verification, they have coined the idea of Lordship retirement. And if your Lordship peruses page 74, this is evidence.
For a moment, let us see what he has written in this application.
Lordship, page 20 is page 20, Lordship.
20, did not talk with the applicant.
House from employment, or and here's admitted, out from service on 17/5/19, Lordship.
I think this at page 21, paragraph 7, it should be 17/5 perhaps, not 9, not 9. I think 17/9 he has written.
And 8 also, it will be 18/5.
18/5. Reinstatement. But learned labor court has come to a finding that he has 18 days of superannuation. That is not challenged by anybody.
Note.
Yes.
But I'll be submitting before the honorable court that initiation of termination of service of the respondent group was bad. After that, the management got the idea of age of retirement. And Lordship, I would like to place before Lordship one more page, page 78, Lordship.
78.
78, Lordship. This document was exhibited because of labor court, Lordship.
Exhibited.
Exhibited. This is the part of the standing order, certified standing order of the petitioner, Lordship. Here, Lordship, age of superannuation and gratuity. May I read, Lordship?
Yes.
Age of superannuation shall be 60 years, but the period of employment of any workman may be extended for any specific period or periods at the discretion of the employer, subject to medical fitness and willingness of the workman. Here, Lordship, this part has been taken care of by the learned labor court, Lordship. Here, what I'll be submitting by the conduct of the management, they have basically waived
this age of superannuation, they continued with him. So one fine day, they terminated the service of the workman. For this lordship, maybe perhaps London Labour Court considered the termination as bad
But you are trying to link some speculation of yours. You may be correct,
lordship.
but these are not the basis of the Learned Labour Code. From where did it come to a conclusion that 2 months' salary the workman is entitled to?
The termination is bad.
So for that, why 2 months' salary? You could have granted some compensation lump sum.
This 2 months salary as compared in lieu of that, my humble submission, the wordings should have been compensation. But whatever labor court has paid, nothing but compensation. I have worked 2 cases where labor court can pay compensation.
No, can pay compensation, but when it quantifies
Lordship.
or make it specific that he is entitled to 2 months' salary, that means there has to be some basis,
Compensation, that part is missing.
Oh.
Otherwise, management initiated the process in a wrong manner. And labor court is held that termination is bad.
Yes, Mr. Kyle, what
I
can
want
be
to
done?
add- Lordship, I want to add one thing. Initially approach the learned assistant commissioner. Lordship, I come to page 24.
Page
Page 24.
24.
Lordship,
Yes.
this is a letter by the labor commissioner. Subject conciliation. You are aware that about the dispute raised by your released employee, Sri Rameshwar Kalita, for reinstatement the service. In this issue, a conciliation is fixed to be held on 21/10/2019 at 3 p.m. So date was conciliation was fixed on 21/10.
Hmm.
Before that, Lordship, he approached the land trial court under section 2, which is not admissible in law. Lordship. Unless conciliation proceeding is come to end, he cannot approach Lordship. Probably my land friend also agree with me.
No, the 48 days. After 48 days.
Lordship, but Lordship, may please to see when he has approached the land. He filed this application on 20th day of January 21. And the conciliation was fixed on 21/10, but nobody appeared. HRO instruction management went there, but no final order was passed by the 11th trial court. Lords.
Where is that application for the before the conciliation?
No,
Page-
page 20.
Page 20.
20. But is there any scope of a labor of a workman approaching directly for a conciliation? It could not happen.
Within
He
45.
comes to 2A by filing a petition, individual dispute. But if you go for a dispute to be referred, it has to be through a union. This proceeding perhaps basic, it's missing in the
Lordship,
threshold.
and we have taken this ground in our WS also.
Now let us not go back. Let us not go into those are not before us. Ultimately, there is an adjudication by the Learned Labour Court on an application which is presumably under 2A. It's been decided. And while deciding 2 months' salary has been given, we do not find a basis for 2 months.
See, absolutely not.
Learned amicus is trying to impress that this is in the nature of compensation. Because your standing order itself says though 60 is the retirement age, it's extendable. So, and his continuation gives an impression that as if he was allowed to continue, more so when he had given him 1 month's salary in lieu of his release, which was not at all necessary. If the
Yes, Lord, it was not necessary.
not
Even then, Lordship,
necessary.
we taking that he was with the company for last 2 years, more than 2 years. So we thinking.
But the moment you say in lieu of notice, that means you understand that there is a requirement of some notice. If he is attained the age of superannuation, he doesn't have any right to continue.
May come to paragraph 7 at page 26.
26.
Lordship.
Yes, please.
Page 26, paragraph 7 is a part of the WS filed by the management.
Yes.
That with regard to the statement made in paragraph 1 of the opposite party beg to state that the opposite party does not know about the skill and technical knowledge of the wood-based industries as well as employment of the applicant in Messrs. SSI plywood industry, which PR West Bengal. Hence, the same is denied by the opposite party. It is admitted that the applicant joined the opposite party's industry on 1/4/2018. But it is totally false that he was ousted from employment on 17/5/2019. He was relieved from the service on 30/4/2019 in the evening. The date 17/5/2019 recorded in the releasing letter dated so and so
We have
was
seen this.
not put at the time of
We have
delivery of
seen
the-
this. 17.5 is introduced by him in his letter. But had the records been produced before us by you, matter would have been different. Records are not before us. Even the records were not before the learned labor court.
No.
So let us give him the benefit of 17 days.
that
One document may help lordship, page 34 may help lordship.
3-4. Hmm.
The account statement of legal account lordship,
Hmm.
the last entry lordship, 18/5 lordship.
18.5, yes.
The amount was transferred on 18/5. The last two is not.
This, what is this amount?
49.
this is a ledger submitted.
Lordship, last amount.
No, no, what is this amount?
Last, 1 month notice period. lordship.
That-
It tallies with the release order.
That may be deposited by the respondent number 2 belatedly, lordship. It is a ledger statement submitted by us.
But Prohibitions seems that 18.5 he
Yes,
had.
lord,
Why
this is a
should he?
ledger submitted by
Why
us.
should he deposit late?
And-
Yes, it may be
and
presumed
one
that
more
it
thing,
was
lordship.
deposited by the workman respondent to
One
lately.
more thing, lordship.
Why will a person's workman deposit a check late?
Lordship, because he is residing in Tinsukia. And it take about 7 to 10 days to credit the amount, lordship. And this is lordship.
7 to 10 days
Yes,
in
lordship.
today's context.
No, lordship,
In Axis Bank,
lordship, it was.
24 hours.
And this, lordship, may please to see, this is the ledger statement submitted by management, lordship, not by the workmen.
And one more thing, lordship,
Just a minute, please. Where is that release letter?
Page
19 is there. lordship.
68 is
3 times.
6874.
19 is also there.
19 also there.
Same letter. lordship. And we
Except the
submitted
date.
at day 77.
Check is 211,550. Okay, okay. Let us not go into all this controversy.
That
No other controversies. Okay.
lordship may produce only one paragraph for a minute.
Which one?
The page 74,
74.
paragraph. This is the evidence on affidavit filed by the manager.
Yes.
Paragraph 4.
Yes.
That during his service period, it was observed that the service of the applicant workman was not satisfactory due to his poor performance and also low production and low sale. Our industry has suffered loss. In the meantime, it appeared that the applicant had attained age of superannuation of 60 years. So I decided to release the applicant from the service of our mill. He was accordingly relieved from the service by our aforesaid such and such. So that stigma was there, lordship. Low sale. This part, lordship, I only want to impress upon this protocol. This is evidence on affidavit of the.
Okay, doesn't matter. Okay. Yes, click it. Heard. I heard no. Don't say this. The instant application, please have your seat. Under Article 226 of the Constitution of India has been instituted putting to challenge an award dated 28/7/2022 passed by the learned Labor Court, Gauhati in case number 1 of 2021. देख लीजिए, हाँ? Put stop by the said award, comma, the respondent to workman has been, by the said award, comma, the petitioner management has been directed to pay full wages for the period 1/5/2019 to 17/5/2019 and 2 months salary to the respondent to workman, full stop. It has also been clarified that such payment has to be made without any deduction from the 1 month salary paid in lieu of notice. The Learned Labor Court has also directed payment of litigation cost of rupees 10,000. Full stop. Para. As per the facts projected, comma, the respondent to workman was appointed as a consultant on 1/4/2018 and on attaining the age of superannuation, he was released from service with effect from 30/4/19. Full stop. However, complaining such action, comma, the respondent two had initially approached the Assistant Labor Commissioner for a conciliation and thereafter approached the Learned Labor Court, presumably under Section 2A, capital A, of the Industrial Disputes Act. Full stop. The case was contested by the petitioner management by filing written statement and evidence was adduced. Full stop. The Learned Labor Court, via the aforesaid order dated 28/7/2022, has granted the relief as noted above, which are the subject matter of challenge in the present petition. Full stop. I have heard Sri S.C. Kyle, Learned Senior Counsel, assisted by Madam, your name? N. Kakuti, for the petitioner. Full stop. Since the respondent two had chosen not to appear, comma, considering the subject matter involved, comma, this court wide order dated order dated 19/6/2026 had requested Sri S. Chakraborty, Learned Counsel, to assist this court as an amicus. Full stop. Sri Chakraborty, the Learned Counsel, is accordingly present for the said respondent number 2. Para. Sri Kyle, the Learned Senior Counsel, has submitted that the present challenge is more on principle rather than the amount involved. He has submitted that though there may be a dispute on the date of actual release of the petitioner, whether it is 30/4/2019 or 17/5/2019, comma, there is absolutely no basis to direct payment of 2 months' salary. Full stop. He has submitted that as per the submitted that according to the stand of the management, comma, the release letter dated 30/4/2019 in clear terms had laid down that such release would be with effect from 1/5/2019. Full stop. He has also submitted that only when the same release letter was submitted by the respondent number 2 with a date 17/5/2019 that the matter had become that another view was able to be taken. Full stop. He has, however, reiterated that the release was with effect from 1/5/19 and the workman in question was not in service from 1/5/19 to 17/5/19. Full stop. He has submitted that from the discussions made on the issues framed, comma, there is no basis for grant of salary for 2 months as directed, full stop. He has also submitted that taking into consideration the services rendered, 1 month's salary was paid to the workman in lieu of notice, which should not be construed to be to construed that the respondent number 2 had not attained the age of superannuation. Full stop. He has hastened to add that the Learned Labour Court had decided issue number 4 on the aspect of attaining the age of superannuation in favor of the management, which is not under challenge. Full stop. Para 3. S. Chakraborty, learned amicus, on the other hand, has submitted that the release letter would suggest that the workman, that the respondent number 2 had not attained the age of superannuation, as otherwise there was no reason to pay a month's salary in lieu of any notice. He has submitted that in the application filed before the learned conciliation officer, the respondent number 2 had disclosed his age as 60 years, and from the same, it appears that the management had taken a cue that the petitioner, that the respondent number 2 can be held to have attained the age of superannuation. Full stop. He has also submitted that from the standing orders, it appears that though the age of superannuation is 60 years, the services can be extended. Full stop. He has submitted, so far as the period from 1/5/19 to 17/5/19 is concerned, the learned amicus has submitted that from the materials on record, including the release letter which was in the custody of the respondent number 2, it appears that such release letter was served upon him only on 17/5/2019. He has also drawn support from the statement of accounts, from where it appears that on the very next date, that it was from where it appears that it was only on the next date, that is 18/5/2019, that the amount was credited to the account of the respondent number 2. Full stop. Para. So far as the grant of 2 months' salaries is concerned, the learned amicus has submitted that the same clearly appears to be in the nature of compensation, which a labor code is authorized to grant. Full stop. He has submitted that taking into consideration the facts and circumstances, no fault can be attributed to the impugned award, and this court may not interfere with the same. Full stop. Para. The rival contentions advanced have been duly considered, and the materials placed before this court have been carefully examined. Full stop. Para. At the outset, this court would like to put on record that the original records of the proceeding could not be produced. Full stop. Para. One of the issues with which the present challenge has been instituted is the direction to pay full wages for the period 1/5/19 to 17/5/19. Full stop. Para. In the materials before us, there are 2 copies of the release letter. Full stop. While the copy placed on record by the petitioner does not bear any date of receipt, the one which was before the Learned Labour Court and was relied upon by the workman bears a date that it was received on 17/5/2019. Full stop. The Learned Labour Court had accordingly taken a view that till such date, comma, the respondent number 2 was in service, full stop. The said view being based on facts and there are no no materials to the contrary, coupled with the fact that the original records have not been produced, comma, this court is of the opinion that it would not be prudent to interfere with a finding of fact arrived at by the learned labor court. Full stop. The issue of the direction to pay wages, full wages for 2 months would, however, require a consideration. Full stop. On a careful perusal of the materials on record, including the pleadings and the discussions made by the learned labor court, comma, this court has failed to find any discussion or basis from which such direction for payment of wages for 2 months have been made. Full stop. The learned amicus has submitted that the aforesaid direction for payment of salaries for 2 months can be construed as compensation. Full stop. Though the learned amicus may be right in making the aforesaid contention, comma, the observations and findings recorded by the learned labor court would, however, clearly show that that the said amount is not by way of compensation which has been quantified, but in clear terms stated as salaries for 2 months. Full stop. There being no basis for making the said direction, comma, this court is of the opinion that the aforesaid direction has been passed without any jurisdiction and is accordingly interfered with. Full stop. So far as the litigation cost is concerned, comma, Sri Kyle Delan Senior Counsel has fairly submitted that the present challenge being on principle, comma, there would be no serious objection to the aforesaid amount being directed to be paid. Full stop. Para. In view of the aforesaid discussions, comma, the instant repetition stands allowed by interfering with the award so far as the same pertains to a direction for payment of 2 months salary to the respondent number 2. Full stop. The rest of the directions of the learned labor court wide the award dated 28/7/2022, however, stands intact.
Much.
Before parting, comma, this court would like to put on record the appreciation for the assistance rendered by Sri S. Chakraborty, the learned amicus curiae. Mr. Kyle, you have to take care of him.
Lordship, probably.
We cannot ask the legal aid council, legal aid to pay him.
That was a discussion with me.
At least some tea or coffee. Mr. Roy?
This is allotment of shop, my lord. Under thing municipal market, my lord. Lordship may see, the shop was allotted to me, my lord, but subsequently it got cancelled, my lord.
You were allotted a shop. What
Shop.
kind of shop? Fair price?
Shop means, my lord, there's a municipal market, my lord. There were underground and first floor shops, my lord. And I have made an application, my lord. Lordship may come to page 24.
Petitioner allotted a shop in Dhing,
Ding municipal market, my lord.
municipal market.
Market. Lordship may come to page.
When was the allotment done?
Yes, page 24, my lord. It was done on my application dated 18/8/2023 on 19/9/2023, my lord.
19/9/23.
23.
Thereafter,
My lord, I've just started the construction of the shop, my lord, because
no, you are allotted a space, that means.
space that means. Space, my lord, and you have to construct.
Space
my
for
lord.
construction of shop.
Yes. So I've annexed the photographs, my lord. I've started construction, but immediately thereafter, in the month of November, that is precisely, my lord, on 29/11/2023, it was cancelled, my lord. The impugned order is at page 27.
Allotment cancelled.
Cancelled, my lord. Now the ground is very, my lord, interesting.
Page
Page
cancellation.
27, my lord.
27.
May I read, my lord?
Yes, just a minute. 27.
Annexure 7.
29/11/2023.
Yes, my lord.
Yes, please.
With reference to the subject cited above, I have the honor to inform you that due to server error on 18/9/2023, the Beti allotted to bearing Beti number 55 of 1 has been shown unoccupied in our Ding MB server. But later it was claimed by Mahabuddin Hazarika, son of Samsur Ali Hazarika, that the Beti number 55 by 1 has already been allotted against him in the year 2015-16, after which cross-checked all old documents and books and found that the claim of Muhammad Mehabuddin Hazarika was correct. In this regard, we regret for our error and apologize you to excuse us. Thus, the Betty allotment number so-and-so dated 19/9/2003 is hereby cancelled, my lord. So the Betty was allotted to him, my lord, 2015-16, my lord.
Mahabuddin Hazarika.
Hazarika.
Who is Mahabuddin Hazarika? Has he come?
Yes.
Here for the Mahabuddin. And Mr. Gupta? Okay.
So lordship will see that is cancelled.
Mahabuddin is response number?
7, my lord.
Okay.
Now the basic ground is that my server error, my lord. Now, then I filed representation, my lord, that this is not correct, my lord. Then the municipal board, they filed their affidavit, my lord, and they have taken their plea that, my lord.
No, but this, it was allotted to you on 19th of September.
Yes.
And this cancellation is out
20
November.
November, my lord.
In this period, did you proceed with the work?
Yes, I've given the photographs, my lord.
You proceeded with the work?
Yes, photograph lordship may see. Page, my lord. From page 25, my lord.
25.
25, 26.
Oh. You had done some construction?
Yes, I just started, and then around 2 lakhs I've invested, my lord. Now the municipal board has filed the affidavit, my lord. Lordship may come to para, my lord, 8.
Of the municipal board?
Municipal board, my lord.
Page?
Page 4, that is page 37.
37.
I think my pagination has not been done, my lord. Para 8, my lord. Yeah.
2, 3, and 4. It is at page 34. AIO by R 2, 3, 4. Dated 28 April. Yes.
Para 8, my lord.
Paragraph 8.
What would answer for it? बाकी सब affidavit ठीक हो.
Yes, please.
Para 8, my lord. They say that that with regard to statement in paragraph 5 and 8(6) of the petition, the answering respondent states that by letter number dated 19/9/2023 issued by Ding Municipal Board, only Beti number 55 by 1 allotted to the petitioner, and no permission is accorded for construction over said Beti, which is required to take approval from the Ding Municipal Board. The answering respondent did not accord any permission for construction of the petitioner over Betty number 55/1. However, immediately having come to know about the error allotment of Betty to the petitioner, the answering respondent cancelled the allotment of Betty number 1 on dated 29/11/2023, and also requested the petitioner to take refund of the amount deposited against the seat allotment. However, the petitioner did not accept the refund, my lord. Then amongst allotee of Betty holders, some lessee already made constructions at their respective Betties, and some lessees did not do any constructions. When the petitioner applied for allotment of Betty at the first floor wide application dated 18/8/2023, the answering respondent allotted Betty number 55/1 since it was shown vacant as per the record due to some error, server error. But when it come to the notice of the said Betty 55/1 was already allotted to respondent number 7 in the year 2015-16. The authority immediately rectified the mistakes and cancelled the allotment so and so, which was inadvertently made in favor of the petitioner, and also requested
Regretted.
regretted, my lord. Now lordship will see then the next statement they made it, my lord. Para 10, my lord, last page 7, lordship may see, para 10, page 7. The end of the para, my lord. The respondent number 7 earlier allotee has been paying. Lordship may see that middle portion of the respondent number 7 earlier allotee has been paying the incidental charges, my lord. I don't know what incidental charges, but the respondent number 7 did not say anything about incidental charges, but it is the municipal board which said incidental charges. After allotment, he initiated plan for construction, but as informed, due to financial constraints, he could not complete the construction at that point of time. Now, he says that he did not, private number 7 said that he did not get the permission to construct. That's why he did not, but here he says that due to financial constraints, he did not, 2015-16, 7 years, it was vacant. Now suddenly he come and say that this Betty has been allotted to him, and he's not, because he did not get the permission to construct, so he could not construct. Now, most interesting, lordship may see page 42, the agreement, my lord. 42. The municipal board filed this agreement, my lord. Now, page 43 is the terms and condition, my lord. That is a type copy, and
This agreement with
with private number 7.
R8.
Yes.
R7.
R7. Lordship may, first of all, the agreement made on 13th day of October 2016.
Yes.
Now, second page, lordship may come for page 43.
Yes.
The term of lease is fixed for a 1 year with effect from the year 2016-17, that is 1/4/16 to 31st/3/2017, which can be renewable after expiry of the lease period after executing a fresh agreement. There is no renewal thereafter. It appears from the stand of the private respondent number 7 and the municipal board, my lord. So it was 1 year lease. Now, next clause number 5, my lord. The lease amount of the Betty is fixed at the rate of rupees 4.5 per square feet yearly, which is payable at the beginning of the financial year 15th April of commencing so and so. There is no proof that he has paid the lease rent also, my lord. Now, thereafter, number 7, my lord. The second party shall have to deposit an amount of 1,000 as security deposit, which is refundable on the termination of lease. There is no proof of paying the security money also, my lord. And last clause is there, my lord. Clause 18 at page 44.
Forty.
44 page, para 18, my lord. In case you fail to renew the allotted Betty within 3 years, continuously the allotted Betty will be treated as cancelled. So there is no proof, nothing, there is no record. Now, original agreement is at page 45, my lord. Now, there is tampering with the agreement also, my lord. This is unregistered agreement, my lord.
Page?
Page 45, my lord.
Yes.
This originated now page 46, terms and conditions, lordship may see. There is overwriting, my lord. First ground floor, then first written. Then again, they strike out the ground floor, the first written. So there is tampering in the agreement, my lord.
Not tampering, they have, some things are written,
Whatever,
these are format.
format, my lord, but
Formats,
when-
see, even the years are inserted by hand.
whatever it is, my lord, I just pointed out that, my lord, this agreement of 13 October 2016.
But you said that there is no renewal, there is no proof of payment of the lease rent, there is no proof of security amount being deposited, and it was not renewed within 3 years.
3 years, and every year lease is renewable, but they have not. There's no
Renewable by
record.
3 years, he has not renewed.
Yeah, every year they have to renew, but they consecutively, if 3 years they fail, then it will be cancelled.
Okay.
Then page 49.
Yes,
Then page 49, my lord.
49.
49. They have issued a letter, the Ding Municipal Board, that not to obstruct them. It is written to me, my lord, on 12/12/2023.
Yes.
Then lordship may see the affidavit filed by the private respondent number 7, my lord.
R7.
R7, my lord. There stand, my lord, lordship may see page 67. 7th line from the bottom, my lord. The deponent states,
Just a minute, please. Yes. This has been filed in June 26.
yes,
Page
page 67, my lord. Last 7th line from the bottom, my lord.
67.
The deponent states that para, this continuance of para 4.
No, it's not be 67. It has to be something else. Para 4 will be 62. 62. That's not
62,
7.
my lord.
That's
Sorry,
two.
sorry, it is written 62, but oh my.
Mr.
62.
Chakraborty is trying to confuse you. He writes 62 in a 67 manner.
My lord, the deponent states, my
Which
lord,
which-
7th line.
7th line.
The deponent states that since he was not
Not
allowed,
7th line. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11th line. Just said 7.
7th line, my lord.
Where 7th?
The deponent says that,
Says that there is no doubt.
that 62,
63.
67,
Page?
page 62,
Yes.
from bottom, 7th line, my
From
lord.
bottom.
From bottom.
Okay. You're correct. The deponent states since he was not.
The deponent states since he was not earlier granted the permission for construction over the bheti, this was contradictory stand, my lord.
Mm.
He was approaching the authorities seeking permission, and finally he was asked by the board to make a formal application seeking construction of the bheti before the Ding Municipal Board for allowing him to construct the bheti number 55/1, measuring 672.44 square feet, and accordingly the authorities allowed him to make construction of the shop of bheti at his own cost, white order dated 3/6/23. That is after cancellation, my lord. So since 2015-16, he remained silent, my lord. If he understood that he has allotted the bheti, 7 years he remained silent, said that no construction, no permission. He didn't move to the municipal authority, doesn't do anything. When it was allotted to me, then, my lord, these all documents there, your lordship knows me, how they have manipulated and done it. On, he says that on 3/6/23, after 15/16, he got the allotment, no construction, nothing. Okay, will it be, is it to be believed, my lord? And whereas the stand of the municipal board is that due to financial constraints, he could not start the construction.
But before your allotment, he was allowed to construct on 3/6.
3/6/23, my lord.
Your allotment,
Mine was, allotment was,
89,
yes.
23.
So my allotment
No,
was
it is not after your allotment. It is before,
just a few days before.
not few days, 3/6.
3/6/23.
You're in 9, you're 18/9, 19/9.
No.
Yes, allotment.
18, my allotment is 19/9. I've made an application on 18/8/2023.
Oh.
My allotment is 19/9/2023. So 19/9 and 3/6/23 is a backdated application, my lord. He could not have got it. If he would have got this application, he would have constructed. He has not constructed. That it appears that this is manipulation, my lord, of records, my lord. Has to be, my lord. Because since 2015-16, he doesn't start construction even. He got his allotment in October 2016, my lord. Just few months back, he got a letter, a backdated letter, and he shown that he's been given permission. And the municipal board stand is that he, due to financial constraint, he could not start the construction. So will it be believed, madam? 2015-16, he got the allotment and he's.
But he says that he was not given permission to construct.
But will it be believed, madam?
It was given only in June
No,
2023.
2015-16, if somebody got an allotment, he will not write to the authorities, my lord, that I don't get the permission.
No, that's a possible, but that cannot be the sole ground of your.
No, that
They
is
are
a-
taking up ground that it was done out of sheer inadvertence. This 55/1 was already allotted. Due to server problem, it was again allotted.
Then what about the agreement, my lord, that lease period, my lord, that every year lease has to be renewed? And 3 years he doesn't continue the lease, then he has to automatically cancel.
No, see, these are grounds which you have taken to justify your challenge. Your challenge is against the cancellation of your
Allotment,
your allotment. We have to concentrate on that.
yes, but.
And concentrate on that. Their justification that it was done due to inadvertence have to be it has to be based on records.
Municipal has not produced the records, my lord, and municipal want to say that some incidental charges, what incidental charges, nowhere in that agreement, my lord, that they will pay incidental charges for holding the allotment. This is only the, he has to pay the lease rent, he has to pay the security. Nothing is there, my lord, on record.
Where is the allotment to the respond number 7?
That agreement, my lord.
No, allotment.
Allotment is not there, my lord, but agreement is there. That I've shown that agreement, my lord.
So 1 year.
1 year agreement, my lord.
That is of which date?
The 16th October 2016, my lord.
Page,
My lord.
agreement at page 42. 42, isn't it?
42. 42.
1310.
The clause 1 itself, my lord, the term of lease fixed for 1 year with effect from 2016-17, 1/4/2016 to 31st/3/2017, which can be renewable after expiry of lease period of and executing a fresh agreement. And 3 consecutive year, if it doesn't pay, then it's automatically get cancelled.
Cancelled. It was not renewed.
Not renewed, my lord. There is no whisper. in the entire petition, either by respondent, private respondent number 7 or the municipal board. And even if we get the construction permission, what prevented them to start the construction? Madam, they waited me to start them. It is
No,
a-
that may not be a ground that he has not started the construction.
No, my
That
lord,
cannot
I
be a
I
ground.
allotted, I started.
Because you have not challenged his allotment. You're only saying that your cancellation has been done on a ground which was not existing. They had manipulated and said that this land was Veti 55/1 was earlier related to respondent number 7, which you say that was not there. And to support that, you have stated there was no renewal. This
No,
agreement
nothing.
agreements appear to be
Nothing.
all subsequently manufactured. That is your case.
And they have not showed any allotment manner. They have showed only the agreement copy. Allotment they have not shown. As an unregistered agreement they have shown. Even they filed the affidavit, they have not shown the allotment, my lord.
Yes, anything else?
That's all, my lord.
Interesting. Yes, who? Yes.
My lord, it was allotted to me in 2016, has your lordship has gone through that, my lord. So my specific stand,
R7. Allotted, where is your allotment letter?
allotment letter I have not given, but the agreement I have given. In the record, my lord. Page 42.
42 we have seen is the agreement.
That is the agreement, 2016.
Yes.
Then, my lord, till date, till he filed the case, I have up to date made payment regarding my allotment. Last payment was made on 30th of November 2022, up to date. Thereafter, he filed the case, so I have stopped payment.
30th of November?
30th of November 2022, up to date payment.
22.
30th of November 2022. 23, he filed the case. Ma'am, on making payment and everything, my lord, your lordship has gone through that order. Page 66. For making construction, this is essential. I'll come to the petitioner's case. 66 specifically allowed me to make a construction on 55-1. And lordship kindly see, 55-1 is the first floor. 55 is the ground floor which is already being held by him. 55, Bheti number 55.
Just a minute. Let's talk first floor. This is application. Yes.
So ground floor is given to him long back. No dispute regarding that. He is having that. Regarding the first floor and the
Petitioner has the ground floor.
My lord.
Yes,
Petitioner already has the ground floor.
Yeah, ground
This
floor,
is
first floor.
only.
Huh?
55-1 is first floor.
So your photograph, Mr. Roy,
My lord.
what are these photographs?
Photograph is the first floor. After allotting the Bheti to me, I started construction, my lord.
First floor.
First floor. No. First floor.
Let's see.
First floor, my lord.
No, let's see.
This is first floor, my lord.
Okay. It won't go down. Not again. Yes.
Then Lordship kindly see, my learned friend is very correct in saying that what is my agreement, what is the continuity and what is the. Now Lordship kindly see, regarding 55(1), he just dropped out of the blue. He has only deposited the money. Where is his agreement? Where is his allotment? Where is the permission to construct? Nothing. Only he has deposited out of the blue. Prior to that, I paid my up-to-date payment. Power to construction was given to me. And then all of a sudden, out of the blue, my lord, he just deposited the money. And he is generating on his right. Except that there is no, he cannot deposit money unless and until there is an allotment and there is an agreement with him. And there comes, after depositing the money, there comes the question of permission for construction. He does not have anything. Except depositing the money, he has nothing. Now, Lordship may kindly see.
Now, this at page 25 and 26. How were this done?
That's what, my lord. He deposited, and what footing he has started.
No, 25, 26. From where does he start? How does he start?
Well, without permission.
Without, how can I start?
Without permission, he cannot show any permission, my lord. He had just deposited. Even there is no agreement, my lord.
Interestingly, Lordship, just for a moment, my lord. Interestingly, Lordship will see the description is different, my lord. Annexure 5, page 24, and page 66 to the square feet, the allotment which was issued to me is 302.876 square feet. That is page 24.
Ground floor.
No, first floor. Page 24 may be seen, my lord. That reference. And here the square feet they are showing is 672.44 square feet. That is page 66, my lord.
66.
Yes. And its category is stated in page 24 that allotment of Betty 55(1) first floor. That is 302 point so and 672. I don't know what municipal board should clarify this.
But ground floor area not necessarily should tell you in the first floor.
Whatever is that,
Say-
my lord, that
say
is their
concept
document.
Construction, my lord. Not necessarily. This is not relevant, my lord. Now, Lakshmi, kindly come to page 22.
Just a minute, please. What is this 24?
24, it shows, my lord, allotment of Betty number 55(1), size 11.6 into 26.
No, this is in your favor.
Yes.
Which Betty? Ground floor or first floor?
First floor. Lordship,
Only document here.
this is serial number 1, it's Lordship will see. Allotment of Betty number 55(1), first floor, approved by chairperson Priyanka Nayak and executive officer Sikha Gogoi, approved, date is 16/9/23.
18/9.
But here is the
Here petty number is same. Here they have 2672.
so it's something, it's less than half. Here they're showing that 672.44 square feet. Agreement কিমান আছে?
এটা এইটো মই ক্যালকুলেট মাৰি চালো এইটো হয়
Where is the area different?
My lord, he is already occupying the ground floor. My lord, the first floor is the 55(1). Not necessarily that his area only construction is there. It's a construction. So
No.
They may clarify this, my lord, because this ground they have not taken. That's why I would have taken this instruction. Because this is something coming up now, right now. So, my lord, they may explain it, my lord, why that is different, my lord. had they taken this ground, I would have clarified it. Now, Lordship, may kindly come to page 22. Is the petition.
22 years. Twenty-two.
My lord. Ah, 22. Can you kindly see? Permission is hereby accorded to so-and-so petitioner to construct the RCC building only ground floor so-and-so, being rather as per the design so-and-so. Any additions, alteration, no alteration is allowed. The vita holder will inform to the office so-and-so. My lord, in every construction when the allotment is there, this permission of construction has to be there. He has also got the permission. Here, my lord, except depositing the money, he has nothing.
This permission is for the ground floor.
Ground floor.
When 2007, there was fire, my lord.
18/6 is 2007, or what is it?
2007, there was fire, my lord. So the market has been burned down, my lord. So this is the permission which they have said that you should not deviate from this.
Permission is accorded to so-and-so, Nirmal, you are Nirmal, son of so-and-so, to construct RCC building ground floor as per design. So this ground floor,
Suppose that is there, what I understand, my lord, now the clarification possibly comes. 80, my lord. 55 80, maybe was given to 2. Here 51 is totally mine. That's why my area is bigger than this. That maybe there is one tapos das is also there. Maybe. So, my lord, I'm just looking at the document, I'm clarifying this. In the ground floor, there are 2 shops. The first floor, it is me. That's why my area is bigger. Now, this shows that, my lord, there has to be an agreement. There has to be a permission for construction. There has to be a deposit of fees. Then only it is his. Here in this case, regarding 55(1), he has out of the blue, he has come and deposited the money only, and there is nothing, my lord. And much prior to that, my lord, I have made up-to-date payment of my petty fees, and then permission was given to me on 6th, and only by mistake or malice or whatever, he was allowed to deposit the money, and he formed his right. My vetty was never cancelled. On the contrary, my lord, I have made up-to-date payment in 2022, and permission was given to me 3 months prior to his transfer. Just in between, he has entered, deposited the money, and what footing he has started construction, my lord. His conduct is like that, my lord. So regarding 50.1, my lord, my only submission is that, my lord, that he has not been able to show that there was an allotment, there was an agreement with him, nothing, except depositing the money, nothing, my lord. This kind of money can be deposited by anybody, they can do in my lord.
but that was on the strength of the allotment order.
No, where is the allotment order? No allotment order. No agreement.
No, agreement is the agreement will follow an allotment order. Page 19.
Mine is
sorry,
allotment, he doesn't
page 20
even have an
24.
allotment letter, my lord.
Page 24,
24
19/9/2023.
is allotment fees. Only fees deposited, my lord. Where is the allotment order?
Or received from.
My lordship,
Oh.
see that allotment of Bajar Bheti, my lord, allotment of Bheti, this is allotment on my application, my lord. This is not normal a fee, my lord.
No, Mr. Roy, this, as a matter of fact, this is a receipt. This is only a receipt of the amount. There has to be an allotment order. Where is the allotment order?
Only his depositor is laying his claim, my lord. My Bheti was never cancelled. my lord.
Lordship may see page 27, my lord. Well, it is, the reference they've said,
20,
the cancellation order will reflect the allotment letter, my lord.
27.
To page 27, the cancellation order, my lord. With reference to the subject cited above, I have the honor to inform you that due to server error so-and-so, the Bheti allotted, bearing number so-and-so, has been shown unoccupied so-and-so.
Now, where is the allotment order?
But this is the allotment, they are referring to this only, my lord, 18/9/2023, my lord. There is no dispute about that. The Bheti was not allotted to me.
18(1) he applied, and 19 the money was deposited.
Lordship may see, thus, last 2 lines, my lord. Thus, the Bheti allotment order number.
No, we are trying to get the number from the receipt. Receipt does not, wait, this is the receipt, this is not the allotment
No,
order.
Lordship, the last two lines, my lord.
Last two lines you have seen.
Thus, the Bheti
We have
allotment
seen
number.
the number,
Yes.
24
Allotment-
oblique 0865.
Yes, yeah, page 24, then see, Lordship may see, on the
Yes.
top of that. DMO, same number is there, my allotment number.
Where?
That on the top, my lord, of page 24.
Where
Top
is
left,
it?
top left.
Top left, my lord.
Top left, yes,
This is the allotment number, my lord.
0865.
This is the format.
Serial number.
Yes.
Money receipt is
89.
referred to as allotment order.
You have the records, Mr. Gupta? Records are there. Records are there. You have the records. Can we have?
Don't have, but I can bring it.
You have to have the records because Mr. Chakraborty and Bruce, Mr. Roy, you come to the page 24.
My lord.
Page 24, if you see the first serial number, allotment of Bheti number 55/1, first floor,
My lord.
approved by the chairperson Priyanka Nayak and executive Sikha, approved date 18/9/2023. So it appears
89
that you may not have the allotment order per se, but there was some application of mind.
My,
Where
that,
18/9 it was approved. Have you got this date? 18/9?
the 89 is my application. my lord.
That is it. It was approved by executive officer and the chairperson.
The record will say, my lord.
That is what. I think Mr. Chakraborty would like to have the records.
Allotment was made, but Lordship was completely due to mistake. Immediately, I think, we have cancelled the allotment.
No, that is what you have stated. That is what you have stated in your cancellation order.
And
But-
regarding agreement, lease agreement, it was formatted agreement in case of petitioner also, that agreement was not renewed, but he is paying the rent every month.
Then it, everything will be clear, my lord. The receipt of money and all this will be clear, my lord.
Yes.
The receipt of annual fee and all that, everything will be clear from the records, my lord, that whether he paid the annual fee, monthly, yearly fee.
I
But
have the receipt, I can- I
but
can
Mr.
take it to the-
Chakraborty, one thing will again arise. Your allotment was in the year 2016.
Yes.
And you say this permission to construct was given only on
23.
3/6/2023,
36.
36 or 36, whatever. From 16 to 2023, what was going on?
The permission is not given, my lord.
Whether there's an,
It's not that I did not pay. Continuously I am paying. Up
No,
to
no,
now.
that is what we're trying to examine your conduct.
Yeah,
You
yeah.
have been allotted, you had paid amount, you have been renewing your license or whatever agreement. At the same time, you are not doing the business. They have not, your defense is that they have not given the permission to construct. It's a first floor. So from 16 to 23, what were you doing?
That's the thing. Madam, that may be irregularity, but unless I have the permission for construction, I cannot. I have referred to the permission given to him. There has to be a permission, my lord, as per the drawing, and he has to do it. So that clear. Without doing anything, he just deposited the money, he has started the construction. Now, Lordship may kindly see his read petition. Is his read petition. What right has flowed except depositing the money? My lord, admittedly, it may be irregular, but I was allotted the Bheti and I'm clearing the payment up to date. And prior to him, a construction order was passed in my favor, my lord. This is my favor. He is usurping my right with what, my lord? When he was allotted, when he applied, how it was given.
Mr. Roy, even if we are not agreeing with Mr. Chakraborty that this is only a receipt, not an allotment order.
well,
Even if we assume that there is an allotment order because this is referred, but the defense taken by the Dhing municipal that it was done by mistake, how do you overcome
no,
that?
lordship will, first of all, the mistake is genuine or not, that will lordship. will
Yes,
examine.
that is what.
Yes. Number two, my
No,
lord.
if
Your
it's-
lordship is correct, my lord.
Mr. Roy, even for a moment, don't think that if it's a mistake which is manufactured to exclude you, then we'll definitely interfere.
No,
But if the mistake is genuine mistake,
no, lordship will first will examine that since 2015-16, what they are doing, didn't they want to say that they are paying rent and they are not doing anything?
That is what we had asked Mr. Chakraborty. That any prudent person will keep on
Not
giving
even
rent
a single
for.
whisper, my lord.
Huh?
Not at a single whisper, my lord, that 2015-16, what prevented them to approach the Ding Municipal Board? Fine morning one evening, they just came and they said that I've deposited fees. Will that be believed, my lord? Without using the property, they are paying rent regularly. I don't think. Lordship will see the records, my lord. Let them produce the allotment letter, everything, my lord. But it is unbelievable, my lord, that a prime location or whatever location, my lord, 2015-16, they are sitting idle. It cannot be, my lord. No prudent person will do it. When I got the allotment, suddenly they show all this, my lord. And when they've seen the structure coming up, taking the advantage, my lord.
I mean, at best, it may be some irregularity on my part. I have full documentation, madam. I have an agreement in place.
Huge
I have
irregularity, not
cleared-
irregularity.
I have cleared my all past continuously I had paid and there is a construction order.
No,
Full document here.
Mr. Chakraborty. Only
Okay,
because
but what happened
only because of your delay in construction, that cannot be the sole factor. But these are relevant consideration. Why will you sit idle for 6 years? Saying- But this may not be the sole factor. If Mr. Gupta can come up and demonstrate that the allotment to Mr. Roy was done by mistake, then matter would be different.
It is a mistake, my lord. He is not saying that agreement is not there. He cannot say that power to construction is not there. He cannot say possibly that I did not pay anything. They'll clarify. It was only a mistake, my lord.
He has the ground
Only
floor.
on the basis of mistake, my lord, no concrete right can be formed, my lord.
You have your ground floor.
I have the ground floor, madam. I'm occupying the ground floor.
Record may be there, my lord. Trustee wants to clarify certain things, my lord.
They should get all the records, madam, including deposit of money receipt.
Okay, we'll have the records. We have heard, given sufficient consideration. But heard is difficult to come. How soon can you get?
Clarify, my lord. Yes, sir. Right.
Okay, heard. Three, dear Leonard Senior Council, assisted by Sri S. Sharma. BP Sharma. For the petition. Also heard Sri K. Gupta, Leonard Council for the Ding Municipal Corporation. Board or corporation? Board. Ding Municipal Board, in bracket respondent was 2, 3, and 4. Sri R. Talukdar, State Council, and Sri B. Chakraborty, Leonard Council for the respondent number 7. The matter has been substantially heard. And in the considered opinion of this court, the records pertaining to the decision making is required to be perused. Para. Sri Gupta, the Learned Council for the Ding Municipal Board, is directed to produce the original records. Para, when can you do?
Tuesday.
Next Tuesday. Okay. Is it possible? Whenever you say.
Sign us. Tuesday.
August.
4th.
4th August.
As agreed to by the Learned Council for the parties, list for production of records and further hearing on 4/8/2026. Yes.
I didn't know.
Yes.
May I please, Your Lordship? My lord, this petitioner's husband was a franchisee under the APDCL from 2007 onward, my lord. Very unfortunately, he died on 12/9/2019.
Hmm.
My lord, as your possibly your lordship is aware of the area, Jamnamukh to Kathiathali, my lord. It's
Hmm.
around 6-7 kilometers. When the petitioner husband died, incidentally, he had the entire Jamnamukh proper, that DTR was in the proper area in the township, which included about
You have
18,
filed your affidavit.
We have, my lords.
We
18
can take it up for disposal.
Yes, yes.
Can we take it for disposal?
Yes, my lords, we can.
Have your seat. Let him argue. Have your seat.
about the area had about 18 to 19 rice mills also, so huge amount of bills used to be collected. After the death, the petitioner wife and the son, he had 2 kids, my lord, 1 son, 1 daughter. Because of it was a prolonged kidney problem, so more or less financially they lost everything. So ultimately, son and mother started to look after the 2 DTRs, that is 2 transformers area. On 30th/4/2020, the executive engineer writes that this person died. My lord, that I'll directly bring my lordship's attention to page 35, my lord.
35.
35. Annexure 3. My lord, this is a letter from Deputy Manager Kothiatuli Electrical Subdivision to the Assistant General Manager Hujai. My lord, over here, if we read, my lord, by letter under reference, it is informed that CBDF Abdul Rahman, who was holding franchisee under this office, has left.
Abdul Rahman is your husband?
Yes, yes. About as per date mentioned and since.
What is CBDF means?
My lord, CBDF is the full form is
What is DTR?
DTR, my lord, it is that particular transformer. my
Now
lord.
that we know what is the full form.
Full form. Oh, let us see. My lord, distribution transformer. DTR. CBTR.
CBDF.
DF agent.
Collection based distribution. CBDDF means collection based distribution franchise.
Collection?
Based distribution franchise.
Collection.
That means there's also
Based.
of collection.
Distribution franchisee.
Franchise.
Yes.
So, my lord, only one thing your lordship may note down also. This person had 2 DTRs, that is DTR number 740 and 739. 740, my lord, on the agreement was done on 6/8/2007. And he was running 739 since 27/1/2012. So, my lord, we come back to that letter, my lord, 35. However, since the agreement is still in the name of deceased husband, Yarunnesa has requested that the DTR 7 739 and 740 are allotted to her by fresh agreement so that she can continue in carrying out activities related to those DTRs in a legal way and can also claim commission in a hassle-free manner in this regard. She had submitted the following documents and closed herewith.
Yes.
So after that, my lord, there are two representations which I have submitted before the Chief Executive Officer of Nagaon Electrical Circle, that is on 3rd November 2020. And another one, my lord, before the General Manager Commercial APDCL, that is Bijuli Bhavan, on 27 November 2020, that is Annexure 4 and 4A.
Yes.
My lord, this is a very important document, page 44, Annexure 5. My lord, this is after Annexure 4A of 27th November 2020. From Bijuli Bhavan, it was asked to submit the performance report of the DTRs, CVDF Abdul Rahman from May 2020 to October 2020. My lord, got it. So, my lord, the DTR numbers
It's written
are
on the heading,
my lord.
above the table, performance report.
Yes, my lord. It's a performance report of Abdul Rahman. That means the name was still there. It was not changed. So May till October, that 739 and 740, this is the, my lord, performance report. And it was signed by the Deputy Accounts Officer.
What 739 and 740 means?
Those
Okay,
two
okay.
DTRs.
Oh, DTRs. Okay.
Yes. In respect of those two DTRs, the performance report was from May to October 20. And it was signed by Deputy Accounts Officer, Kotiatuli Electrical Subdivision. Possibly, my lord, it is 2/12/2020. Or it is 12/12/2020. I'm not sure, but I think it's 2/12, my lord. 02 possibly.
212.
Yes. And then subdivisional engineer. So this is the performance report. My lord, Annexure 6 series is very important. My lord, this Annexure 5, your lordship may note down in one side, my lord, that Annexure 5 and 6 series, there is no whisper on the part of the respondent regarding the claims. What I say, that in pursuance to my representation, you asked for a performance report. The performance report up to October was submitted in respect of my performance against these two DTRs. Then Annexure 6 series is the amount I collected. My lord, this is, my lord, this page 45 is the typed copy. 46 is the main copy, my lord. That was given for the month of May, dated 27 May. Your lordship may underline it, my lord. 27 May.
Where do you get?
My lord,
27/5/2020.
yes. So that is May 2020. My lord, this way your lordship may come to page 47.
These are the bills collected.
These are the fees collected and deposited.
Yes.
My lord, page 47 makes it clear, my lord, because then possibly on my advice, I said give it a typed copy. This is the amount, total amount, 5,25,152, my lord. And these are the amounts given, and it is collected by the accounts officer, which is also signed by the subdivisional engineer. So, my lord, I'll come to, that is from May to June. My lord, June is page 50, June 2021, that is page 59. This is the 6 series, my lord.
$59.
59. Page 59. That is deposited date 23/6/2021. Amount is 2,25,060 rupees. My lord got it.
36.
So, my lord, May 22, June 21, that is 14 months. This is one of the part of the case, my lord. This 14 months commission, they denied to give it to me.
Yes.
Then Annexure 7, my representation, that is 15 December 2020, for allowing me to continue to manage the operation of the DTRs number so and so. And there was another DTR which ultimately was not listed in their record, my lord. But that was in my land through.
There was a third DTR.
That was the third DTR. It was the office did not give it. I got it through the MLA quota, and it was installed in my own land with their permission, and I was collecting the revenue and giving it also. Then, as nothing was given, my lord, then ultimately I approached this honorable court.
Your grievance is that your commission was not given.
No.
Yes.
And second grievance is, my lord, my load security was paid only in the 2025, but without any interest, though the interest is under 47(4). My load security amounts, whenever they have to give it to me, they have to give it to me with the interest, my lord, at the present rate of interest. But they have, I don't know how they deducted, from where they have deducted lots of amount, though in 2024, that I'll come to my affidavit in reply. It has, in 2024, there was a certificate saying there is nothing against me. I don't have any liability. That was clearly given.
Who had given that certificate? Who had given?
My lord, I'll just give it. That is the Deputy Manager, Kothiatoli Electrical Subdivision.
Page?
That is page 119 of my reply, my lord.
One
119. Last, my lord. Annexure R1.
What is this?
This is to certify that the IBDF franchisee, my lord, that from CDBF to then the term changed to IBDF. I don't, what is the full meaning of IBDF? DF. Electricity. My lord, over here has no liability against DTR numbers 739 and 740 operated by him under Kothiatoli Electrical Subdivision. So this is given by the Deputy Manager, Kothiatoli. My lord, my immediate boss and management. And
now you said that you have had two DTRs.
Yes.
For which commission is yet to be paid to you.
Yes, my lord.
There was a third DTR.
Yes, sir. I'm not claiming now, my lord.
Now, these two DTRs, 739 and 740 are concerned.
Yes,
This certificate of 15/10/2024 states that there is no liability.
yes.
So
But-
your present petition is for what?
What I'm saying, my lord, but if your lordship looks at their affidavit, they have deducted in the year 2025 after the certificate from my load security amount. And another thing, my lord, would your lordship be pleased to come to page 114, my lord, of my that affidavit, my lord. One one four. Para 5 of reply, my lord.
This opinion opposition is dated 20 July 26. Para?
Para 5, my lord. My lord,
Yes, please read.
may I read it, my lord? Para 5. With your lordship's permission.
Yes, please.
That with regard to the statements made in paragraph 7 of the counter, the deponent begs to state that the authority paid rupees 2,29,915 to the deponent, and the deponent received the said amount on 9/1/2025 through her bank account. The aforesaid amount was the return amount of load security amount of two DTRs, that is 739 and 740, amounting to rupees 2,56,204, deposited by the petitioner, that is the dates on which I deposited, my lord, as evident by Annexure 2 series to the writ petition. It is not clearly stated as to how the load security amount was reduced to 2,29,000. The calculation chart as presented by Annexure B to the counter is a vague one without any proper explanation or reasoning. Next, my lord, another important aspect is that the deponent submitted two commission bills. That is very important over here, the second part, my lord. Bill in respect of November 2019 to April 2020, 6 months, that they admitted, and they said it is 5 months. So, my lord, whatever the documents I had from my husband's file, I knew that it was from November, it was pending. So I made it from November. They said no, November is paid from December. Agreed, my lord. So ultimately they have admitted 5 months till April 2020. My lord, if your lordship comes back to one thing, that April 2020, why they are saying that letter, my lord, when the deputy manager informed that I was running the two DTRs and my particulars I have submitted so as to allow me to continue that Annexure 3 which I have in the writ petition.
What are you seeking in this, Mr.
Me,
Abhinan?
my lord, that is in page 117, my lord.
No, what are your prayers in this petition?
Prayers are there, my lord, but only things now it comes to, my lord, 117, my lord. These are the three things, my lord. One 117 para 9, my lord. My lord got it. My lord, these are the three things. Accrued interest on delayed payment of commission bills for 5 months, that is from December 2019 to April 2020. The amount was admitted, but the petitioner received the payment only on 27/5/2025.
Yes.
Over here, I would say only one thing. If your lordship is aware,
Here in paragraph 9, 117, you are seeking basically
these three things.
accrued interest on delayed payments, accrued interest on load security amount, and commission for 14 months.
14 months that Annexure 6 series, where they
Mr.
did not deny.
You are Mr. Sharma.
Yes, my lord.
What is your instruction?
Well, only one thing.
No, where we are hearing you. Just immediately.
Most importantly, the
petitioner, after the death of the petitioner's husband, that was on, I think 12/9/2019. There was no intimation as such to the board that there was the death of the contracting party. So from 12/9/2019 till 30/4/2020, that's when we received the information from the subdivision that the contracting party has expired on this date. So therefore, if there is no existing contract, there is no point of the whole DTRs running legally. Therefore, post
When was it intimated, the fact of the deaths?
through a representation that the petitioner has
Which
sent.
date?
Well, that's one. It's in the representation.
See, Mr. Sharma, the objection which you have raised, in the facts of this case, it may be a technical objection.
Yes, ma'am.
It is not, are you denying that the duties, the role which was entrusted to the petitioner was not done by the, entrusted to the husband was not done by the petitioner? That perhaps was done. He is only asking for commission for 14 months, which then the accrued interest and the delayed payment. And load security, he says that you cannot hold back.
As per your question, it's in annexure number 3.
Page
35 of the writ petition.
35.
Yes, my lords.
Yes.
It is wide letter under reference. It is informed that CBDF Abdul Rahman, who was holding franchisee under this office, has left for heavenly abode as per date mentioned, and since then his wife Iarun Nessa has been looking after the operation and maintenance of the allotted DTRs. However, since the agreement is still in the name of her deceased husband, Iarun Nessa has requested that these are allotted to her by fresh agreement. That she has requested to the subdivision office that these be given to her, although by the fresh agreement. Now, my lords, as per the instructions that we have received, now there was an earlier writ petition.
Was a fresh agreement entered into its?
No, my lords. No, my lords, because now if I may, if your lordships may kindly read page number, para 6 of our affidavit in opposition.
Page
95 of the affidavit in opposition, my lords. My lords, that pursuant to such directions passed by this honorable court, there was another writ petition, and it was disposed of with certain directions that there may be a speaking order coming from the department.
Another writ petition by the same petitioner?
Yes, my lords.
Why, Mr. Abidin?
By the annexure 12, page 78.
You wanted to carry on with the...
Yes, I wanted to carry on. It was everything was taken care of by this honorable court while disposing that writ petition.
What was the direction?
It was the direction, my lord. In view of the above submission made by the learned counsel for the parties, this court is of the view that as the representations supra submitted by the petitioner before the respondent authorities are pending and the same are yet to be disposed of on consideration, it would be appropriate, considering the request made therein, that the respondent authorities give consideration to the representation in an expeditious manner. Thus, instead of
how did it end up, the consideration part?
by impugned order, my lord. That is page 14, which is under challenge. Annexure 14, page 87.
Okay, let's come back at 2 o'clock. Page 80.
Page 87.
My lords, I'll just take 2 minutes of your indulgence.
So we'll come back at 2 o'clock.
The speaking orders answers everything that has been annexed in our affidavit in opposition.
Now, what is 87 then?
87 is the speaking order.
He is put to challenge this.
Yes.
We'll see whether it's sustainable or not. Okay. At 2 o'clock, we'll come back.
All right.
The speaking order has been passed pursuant to the earlier direction of this court.
Yes,
Of this court, my lord.
Okay. What is it? Decide about. Person, na?
Nine, the Buddha matter become infrastructure. Petitioner got relief. So please,
Lordship in 8 and 9, your lordship, both the petitioners have got their monetary relief, your lordship. We
18,
like to
what are
withdraw
8 and 9? Okay. You are for the petitioner?
Yes, your lord.
You are Upreti?
Yes, your lord.
What Upreti? D.
D. Upreti.
You are not on record.
No, your lordship.
I'm there, Lordship.
Oh, you-
As Dole. So,
You are as Dole. Okay.
yes, Lordship.
Heard Miss as Dole, learned counsel for the petitioner, separate orders. Huh? No, at audio petitioners. Also heard Sri S. Datta. Pura naam likha,
Satyajit.
Datta, learned standing counsel, revenue department, and as well as Sri Artalu, heard Sri Artalu, learned state council, as well as Sri Satyajit Datta, learned standing council, revenue department. Para. It is jointly submitted in the bar that by flux of time, both the writ petitions, the writ petitions have become infructuous. Full stop. The writ petition accordingly stands closed as infructuous.
8 and 9.
8 and 9.
Yes, please, the lordship.
Yes.
I victim item number 14, my lord. Earlier, I made a mention, but without the consent. I have taken the consent from the APDSL authority, my lord. Lady matter may be listed on third, my lord, if you lord, please.
14.
14.
And a
Third.
request made on behalf of the petitioner. Matter is adjourned to be listed on 3-8.
Yes, ma'am. Obliged.
Mr. Bhuya, which matter you are waiting for?
19.
19.
Right.
Hearing matter. Let us see if it reaches, we'll try to do it. But this is going to take some time. Okay. And Mr. Senapati, which one? This is what item?
Item number 4.
4. Will it reach your items? Will it reach? There are a few matters which have been adjourned in between, but there are other matters also. And we are trying to have a disposal at the admission stage. Okay, let us see if it reaches. Yes.
Lords, if I may, if your lordships may kindly see page 101 of our affidavit in opposition.
101.
Lords, the speaking order, as per the directions given in writ petition.
You are justifying the impugned order.
Yes, my lord.
101.
Repetition.
You have already given a thought consideration to the case of the
We have,
petitioner
we
pursuant to the
My lords, the
earlier orders of this court.
factual-
And this is your finding, these are your findings, 101.
Yes, my lords. Lords, as per the factual position, we came to know about the death of the petitioner on 30/4/2022. Therefore, the payments as such have been made up till that date. Now, my lords, our admitted position in the affidavit itself. If my lords may see page 96 of our affidavit in opposition, there we have mentioned
90s?
96, my lords,
Yes.
affidavit in opposition. Now, there we have mentioned from, if I may read from the second line, further, after examining the claims of the petitioner for payment of commission/incentives bills up to June 2021, it was seen that after the demise of the husband of the petitioner, who was initially the contractual party, on 12/9/2019, she, along with her son, had been unauthorizedly carrying out on the works of the franchisee without any intimidation to the APDCL up to 30/4/2020. That's when we came to know of it. through the representation that has been sent by the petitioner to the subdivision asking for a fresh agreement. Now, my lords, if I may continue, thereafter from May 2020, in the same paragraph, such works were taken over by the Kothiyatali electrical subdivision of the APDCL. Be that as it may, since the APDCL received the services from the petitioner up to April 2020, that's when we came to know of them. CBDF DTR incentive commission payments were allowed up to that month, subject to final accounting. Therefore, the annexure that we have attached to our affidavit in opposition, the payment is up till 30/4/2020. That's our admitted position. Now, my lords, why we did not move for a fresh agreement? The justification of the same has been given in the speaking order as pursuing the directions of the court.
Yes.
If my lords may kindly see 101 page of the affidavit in opposition, page number 101. That's where the speaking
That
order
means
is
from May 2020, the petitioners, they have not.
There is no contract, my lords.
No, first on the death of the husband,
Yes,
the
my-
contract stood terminated. Nonetheless, they continued.
Yes, my lords.
They continued,
Without any
but,
intimidation, my lords.
from May 2020, you had taken over.
Yes, my lords, that's our admitted position in our, the Kothiyatali subdivision had taken over the whole work out there.
And in 2022, they represented to have a new agreement.
They have sent couple of representation. And why we did not go for a fresh
What
agreement?
about the position from May 2020 to April 2022?
April 2022. My
From
lords,
May 2020 to April 2020, what is happened? Who had run the show?
the work was being done by the Kothiyatali subdivision, my lords.
Not by the petitioner.
Not by the petitioner, my lords.
Okay, that means the entitlement would be at best up to May 2020.
30/4/2020 is where everything stops with respect to the previous agreement.
Okay. Not 34, yes, 34, April.
34, yeah.
Yes.
April. Now, my lords, if my lords may kindly see page 101.
Now, what do you want, Mr. Abedin?
No, my lord, what my friend is saying is contradictory to the annexure 5.
No, what do you want?
My lords,
No, just a minute. Is it a fact that from May 2020, the work
No,
has been taken?
absolutely wrong. Annexure 5 and annexure 6, they did not make a whisper or denied that.
my lords,
Annexure 5 is the performance of mine,
my lords,
which I have mentioned, my lord.
may I just get the
And
opportunity to
annexure
clarify?
6 is the, 1 minute. Annexure 5 is the performance, my lord. Would your lordship be pleased to see it again, my lord? Annexure 5, that is page 44, annexure 5. My lord, this is up to October. This is my performance. And annexure 6 series
My lords,
is the,
may I
Okay,
clarify?
okay, well,
my lord, one thing, they suppose they have taken everything from me. There would have been one letter saying that you have been stopped, we are taking over. And my lord, it's not that. Till June 21, I have done it. And from July, I was under them. They had a fresh agreement with me. It is there, my lord, in that
In the
annexure 9 is the fresh agreement with me.
Okay, we'll come back to you. Let him come.
My lords, now that we have come to the performance report, my lords, it's very clear from the performance report. If my lords may read the heading of the performance report.
Yes.
Performance report of DTRs of CBDF late Abdul Rahman from May 2020 to October 2020. 30/4/2020, we are aware of the fact that Abdul Rahman has passed away. Now, this performance report nowhere mentions that the performance is of the petitioner. It is, for example, my lord, it could have been of the subdivision, Kothiyatali subdivision. Now, my lords, and this is very important, my lords, para 13 of the writ petition.
30.
13, my lords, page
13.
11. Page 11. My lords, if the performance report was of the petitioner, it would definitely have been intimated to the petitioner in person. This specific line in para 13,
Yes.
the last line before the annexure, it's written, the petitioner managed to obtain a copy of the said performance report. She was not intimidated of the same.
No, I was not.
My lords, therefore, this performance report is not specifically of the petitioner. It could have been of the subdivision, Kothiyatoli subdivision as well. It just writes in the, it finds a mention in the heading, the DTRs of late Abdul Rahman, where we have also acknowledged that the person has passed away. And my lords, of the 2021 agreement.
No, Mr. Sharma, we are not going into speculations. Either he has done it or the Kathiyatili has done it.
Lords,
We cannot presume. See, you are the authority. Either you say with affirmation that we have done it, he has not done it. From the performance reporter, you say that it cannot be presumed that he has done it.
My lords,
You are the authority, you have to say us.
my lords,
If it's a
it's-
disputed question, then we have to take another view. If we are, but we cannot go by presumption.
my lords,
You will not give a performance report for works done by yourself. Why will you give?
my lords, it was obtained by the other side. We were not given there. It was obtained by the petitioner
Yes,
side.
agreed.
And my lords,
And my lord, Annexure 6 series is the payments made.
But why then collection efficiency, outstanding? What are these
Just with
headings?
respect to the deductions that being made, with respect to the thorough bill, if your milords may allow us, we may place additional affidavit on base of it or additional
Not
instruction.
additional, if you get the instructions.
We get
See,
additional
you have
instructions.
filed your affidavit, we'd like to see the records also. See this, page 44 and 45.
Yes, my lord.
Put it, yes, ma'am.
See, these are generated or these are prepared only when it is done through a franchisee. Where is the requirement to prepare this performance report when it is done through your own office? Where is the question of outstanding, collection efficiency? Where is the requirement? Just give a thought.
My lords.
See the headings under which the different figures are stated in page 44.
My lords.
You may be right in contending that only by naming the DTRs and CBDT of late Abdul Rahman may not mean that they have run.
Yes.
But what are the headings under which the figures have been said? Month, DTR. DTR is the name, 739 and 740. Current demand, area demand, total collection. Outstanding is what? And collection efficiency.
My lords.
This you do only to make an appraisal.
Yes.
If it was not under a franchise, there is no necessity for appraisal. There may be, you instructions may have be otherwise also.
Yes.
We not know about prima facie.
My lords, our admitted position is that we are the ones, the subdivision of Kothiyatoli division, and they have started the work. It's admitted in our affidavit.
From May
petition.
2020.
From May 2020. Yes, my lords. 34/2020 ends. 1/5 is where we start.
And you have been paid till 34.
Yes.
Thereafter, you have not been
No,
paid.
because of that letter of 30th 4, they stopped at that. And after that, my lord, I continued. I can, with absolute authority, I'm saying.
No,
continue-
that's a different matter.
Yes, my lord. And-
Your instruction may be correct, may be incorrect also. We as a
No, it's not, my lord, it is not incorrect. It's not an instruction. I know it.
No. Yeah, as a council, you cannot.
Yes, on
Yeah, as a
council.
council, you cannot put in your personal
I
knowledge.
understand. As
We
a
cannot-
council,
you
my lord,
cannot-
my instruction is correct. my lord.
We'll have to go by the records.
I understand, my lord.
You cannot equate yourself with the petition.
No, I'm not. But only one thing, your lordship, my lord, what my friend is saying, that means if I did not, my lord, one thing, suppose I
Mr.
ignore.
Abedin, see, we don't want to enter into the realm of disputed questions of fact.
I understand.
If you are making a statement, affirmative statement, which is disputed by Mr. Sharma, then you may be correct, he may be correct, but we don't have the expertise to come to a conclusion who is correct
My lord, only one thing
in
I'll
absence
say.
of evidence.
I'm leaving that apart. My lord, only one thing. Suppose we did not, we have hidden something and we are asking for something. The FDCL being my kind of an employer, they will not treat me in the manner they have treated me in page 68.
What is 68?
This is the agreement with me. When I said I cannot do the maintenance and collection because of your non-payment, then they gave me this e-Subhida. This is an agreement. Suppose I was bad, they would not have done it with me, my lord.
What is this agreement about?
My lords,
This
this is
is-
a very different agreement. It's the work of the operation is very different.
What
compared to
I'm
the previous
saying,
agreement.
I'm not saying the operation
It's
is
not even-
different. I'm saying is the conduct. If I was not having a good conduct, they would not have done it with me.
Mr. Sharma, where is your statement that in this period you have done the Kothiyatali has done the work?
Give me a second. It's in our affidavit in opposition.
And my lord, where is the thing they have denied
Just a
that
minute,
Annexure 6 series?
Just a minute.
My collection and payment to them. They have received it with seal and everything.
My lord, it's also in the speaking order. I'll just read it out. My lords, page 101 of the speaking order, the annexure of the affidavit in opposition. That's a speaking order.
14, just a minute, please. 14. Now, speaking order is okay. Where is your affidavit in opposition?
My lords, if I may read,
Where is the affidavit in opposition?
affidavit in opposition, my lords,
From
starts from page 93.
93.
Yes, my lords.
Where is your reply to 14?
My lords, page para 6. White, if I may read.
This is not your affidavit in opposition. This if you have chosen not to go parawise, how
No.
do you see what have you stated in paragraph 3? Instead of giving a parawise reply to the writ petition at this stage, the opponent seems appropriate to confine the affidavit to the extent of disclosing the stand. They have made a positive statement in paragraph 14 regarding this collection. Where is your denial?
No denial at all, my lord.
No, you cannot.
My lords, we have also admitted that it's been us who's been doing the work in para 6 of the affidavit in opposition.
Paragraph 6.
Yes, my lords, if I may read that line, specific line.
Now, Mr. Sharma, there is something called pleadings. There has to be a denial, not evasive denial, specific denial. That you have not done. You have not dealt with this paragraphs.
My lords.
This is not, see, you file a consolidated affidavit for matters of clarification
My lords.
or a preliminary point which you think will bring an end to the litigation.
My lords.
Taking leave that if needed, we'll file a detailed affidavit in opposition. We do that at time, we allow it.
My lords.
But this is your general defense. If you're fighting your general defense, you have to meet the statements. Either you accept or you deny. You have the liberty to deny.
My lords.
And those would be matters of examination by us. But we don't find denial.
My lords.
You file a better affidavit, another way granted, and more than that, you have the records.
My lords.
If from the records you make out that your speaking order is based on the materials on record, including the fact that from May 2020, it is the Kothiyatali subdivision which is doing the work, then Mr. Abedin may not have a case.
My lords.
But it has to be supported by the records.
My lords.
If it is
Okay.
there, my lord, I'll go.
Okay.
But I know that till June I worked, and after that from July, easy money option was given to me that you just collect the bill, then they give me only 3%. Earlier, when I maintain the DTRs, that comes to 15%. And my lord, another thing, admitted amount is still up till April, your lordship, for argument's sake taken. When I have to pay the amount within the month, why do you take 7 years to pay, return me my commission amount?
Till April also, it's not been done or what?
It's done 2025 after filing of this writ petition, after when my lord's order was there.
My lords,
That admitted amount you paid, that is in 2003, but ultimately in 2005 they paid
25.
25. Instead of 6 months, they have paid 5. I agreed. But there also deduction. When I have shown the order, my lord, letter that in 2024, there is a clarification from the Kothiyatali that there is no liability against me. And then incidentally, after that, they have given the load security amount to me with another deduction. And my lord,
No, those we can consider.
Yes,
Those
sir.
we can consider.
with respect to the financial statement, as I have placed my submission here, we'll get additional instructions on it. My lords, the High Court's order was
How
in
soon can you
2021.
file? How soon can you file? This is pending since when?
2023. My lords, we didn't take 7 years. It was the order was on the High Court order of the previous writ petition was of 2021. And my lords, those 7 months are disputed because they have been operating unauthorized, my lords, as we have placed in our records, our submissions here. Therefore, be that is it, as we had, in order to clear things, we have made the payment. However, the fact remains that the operation of those DTRs have been going on unauthorizedly.
Okay, heard. Three. J. Abedin, learned counsel for the petitioner. Also heard Sri S. Sharma, learned counsel appearing on behalf of the APDCL. Put up from a perusal of the materials on record, including the affidavit in opposition filed by the respondent numbers, by the respondents, it appears that the averments made in the writ petition were not specifically dealt with, and rather, in paragraph 3, a statement was made that the affidavit was confined to the extent of disclosing the stand of the APDCL. Full stop. Para. The claim, the relief sought for in this petition are specific in nature, for which averments are clear, for which clear averments have been made. Full stop. To in the interest of justice, this court is of the opinion that an opportunity be granted to the respondents to file affidavit dealing with the pleadings specifically. Full stop. It is this court would also like to peruse the concerned records based upon which the impugned speaking order has been passed. Yes, full stop. Matter accordingly stands adjourned by 3 weeks. 3 weeks?
That's 4 weeks. Giving 4 weeks.
No, 3 weeks. 3 weeks. You already have the record. 3 weeks to enable filing of affidavit in terms of today's order. The records as indicated above are also directed to be produced. Put the list on today is 28th, no? 1, 2, 3. We'll have it on 24th. You get enough time. 24th of August.
Obligement. Oblige.
24th or 25th, madam. We can finish it off.
24th also. Okay, no problem. 24th.
Yes, madam.
Yes, next.
I did say.
Affidavit filed.
Affidavit has been filed here.
Okay.
The admitted amount was is 37,40,240 rupees.
Page 57 of our affidavit.
Who is R4? Deputy Commissioner of Police.
Yes,
Commissioner of Police.
Commissioner of Police.
Which paragraph?
Using paragraph number 5.
Page number 57.
11 page is the page 57, Lordship. Deponent further backs to status.
Okay. May to hear you. Your JK Bhuya?
Yes.
Heard 3 JK Bhuya, learned counsel for the petitioner. Also heard 3 SR Barua, learned state counsel for the respondents. Para. The instant petition has been filed for a direction for release of higher charges of the vehicles which were utilized by the respondent authorities. Full stop. It is the case of the petitioner that vehicles, 5 vehicles bearing registration. What is the make of the vehicle?
This were bus,
All buses.
all buses.
That 5 vehicles within buses bearing registration numbers. What did you instruction? Yeah, that's it. It's enough. That's it. AS077 were hired by the respondents from time to time, and bills were raised. First of, however, there has been an outstanding of an amount of rupees 49,13,518. Full stop, as the same was not paid, comma, the instead petition has been filed. Para, the scope of interference by a writ court in matters pertaining to contractual dues is limited. Full stop. However, the Honorable Full Bench in the case of Tamsir Ali versus so-and-so, report in so-and-so, has laid down certain guidelines in which a writ court can interfere and pass necessary orders. Full stop. That's why paragraph diba. As noted above, comma, amongst others, it is necessary to have an acknowledgement of the liability in writing by the chief engineer oblique head of the department for entertaining a writ petition. Full stop. Para. In the instant case, however, it is seen that the respondent number 4 has filed an affidavit on 16/7/2026 admitting the liability. Full stop. Sri Barua, the London State Council, has submitted that in the affidavit so filed, comma, there is an admission of the admission which, however, is is however of an amount which is lesser than the amount claimed. Full stop. He has also submitted that once the sanction and allotment of funds is there, comma, the outstanding would be paid to the petition. Para. In the affidavit in opposition so filed by the respondent number 6, comma, in paragraph 5, comma, the liability has been acknowledged, comma, the relevant part of which is extracted here in below page 57. In view of the aforesaid facts and circumstances and the admission of the liability by way of an affidavit, comma, this court is of the opinion that the principles laid down by the Honorable Full Bench in the aforesaid case of Tamsir Ali, bracket Supra, would be applicable. Full stop. Para. The writ petition accordingly stands allowed by directing the respondent authorities to treat the claim of the petitioner in the manner indicated by the full bench and upon and release the outstanding in an expeditious manner and in accordance with law.
The affidavit filed by respondent number 4, not
4.
6. 4.
4 we have said. Respondent number 6 we said. 4 we will be said. Affidavit filed by respondent number 4. Yes, much obliged.
Please, John. Now, this is a writ petition on behalf of the All Assam Fair Price Shop Dealers Association. Now, I have prepared a short convenience compilation, Your Honor. Do you have a copy? So I've extracted all the relevant documents and statutes in one place. Am I no? Now, Your Honor has the compilation?
What are you seeking?
Yes. So now, once the National Food Security Act comes into operation, a new regime for compensating the fair price shop dealers is introduced. Now, under this new regime, they are paid margins. These margins are of two types. One is a basic margin and one is an additional margin. This comes from what are called the assistance rules. Now, these margins are paid to the authorized agencies, which are what are called GPSS, Gram Panchayat Samabay Committees. So GPSS have a separate margin and fair price shop dealers have a separate margin. Now, these margins have been, in my respectful submission, illegally bifurcated, and part of the fair price shop dealers' margins have been paid to the GPSS. So I am now eligible to receive 143 rupees per quintal distributed for a period, for one set of periods from December of 2015 to to April of 2019, I've been paid only 100 rupees. And then from the subsequent period of April 2019 to March 2021, I've been paid only 130 rupees. There's 133 rupees. So there's a 10 rupees gap. So these are the two sets, and they aggregate to huge amounts, approximately 373 crores spread out over 70 crores spread out over all the fair price shop dealers. So this is as far as basic margins are concerned. The second set of dues is to do with what are called the additional margins. Now, the additional margins are to do with the EPOS machines, the electronic point of sale machines that all the fair price shop dealers have had to adopt. And this starts from 2022 till date, not a single rupee paid. So in a nutshell, these are the claims I have against and these are statutory margins that have to be paid. And my argument is that if these amounts are not paid, it directly goes to the viability of the fair price shop dealers, which respectfully the state has a duty to maintain the viability, because otherwise it completely gives negates the objectives of the fair price of the National Food Security Act.
What is the defense they are having for not paying?
So their defense is, as far as the basic margin is concerned, the defense is in three parts. First, they say that this is required because the GPSS are doing extremely hard work and last mile requirements are there by the GPSS. That's why we've given that amount. They call it a still prevailing system. I will show that that's not prevailing. In fact, they've admitted the mistake in a judgment before this honorable court in a separate writ petition. In fact, the cabinet is also taken away the original split that was there. The second argument that they have raised is, one second, I'll just inform your honor. The second argument is to do with flexibility. They say that they have certain flexibility to decide how much to pay, who to pay. Now, and this flexibility comes.
This flexibility will override the statutory requirement.
Not at all, because the flexibility actually, your honor, comes from the statute itself. There is a Rule 7. Rule 7 is the main rule. Now, Rule 7, Sub-Rule 8 considers when can flexibility happen. And flexibility can only take place if between one fair price shop dealer and another. If one fair price shop dealer is given 143 rupees, but let's say another one is up on a hill somewhere, so he can be given 153 rupees. So there can be flexibility within, but a rationale has to be deployed. Why? And the rationales are given: hilly region, remote regions. These are the things. Flexibility doesn't mean that my share of the margin can be given to the authorized agency, which have a different head altogether. They receive 100 rupees per quintal distributed. So my 143 cannot go there and his 100 cannot come here. And the third explanation, your honor, is, I have it here. And the third explanation.
You want to submit that the flexibility clause has been wrongly applied. It
There is
doesn't
no
have
flexibility. Actually, this is a belated case. They have not applied flexibility because when they have reported these amounts, now there's a duty under the TPDS, targeted public distribution system order. There's a liability cast on the respondents under clause 9, subclause 7. There's a liability that they have to fix the price of how much a fair price shop dealer will.
Mr. Mazumdar?
We have filed our epidemic.
No, but if it's a statutory requirement, how can you do away with the requirement of statute? No, I just tentatively are asking this to have your immediate response. We'll hear Mr. Das properly. But what he has indicated, these are rights which accrues to him from a statute. And it is specified Now, can you tinker with that, right?
That we cannot tinker actually. That we cannot tinker.
So you may have other reasons which for which inconvenience, for which you can are not being able to follow, but
Yeah.
your justification doesn't seem to be in sync with the statutory requirement.
Requirement of the statute, we cannot tinker. That is correct.
So how do you resolve this?
We have filed our.
Is this a dispute which needs a resolution by a court? I think it's in your hands. If the statute says this requirement, we cannot, whatever you might say, cannot say unless the statute you are putting to challenge, or it's your creation. You have to follow it. He's not asking for anything more. He's asking for 100 and 143.
In fact, subsequently, the cabinet decision was taken where the amount due under the statute was paid. The lordship is supposed to affidavit of will fine. Subsequently, it was paid.
No, what we are thinking aloud, is it a dispute which needs a resolution from the court?
They are asking for it.
Unless you say that no, their projection is not correct. Here, there is no projection, there cannot be a dispute of facts. He is only asking implementation of the amount specified. Why don't you advise your state? It just needs some thinking and application, that's all. And the entire objective of the 2013 Act, that was the sole objective, to bring transparency so that they are also not in a position of inconvenience. Because in the name of fair price, many things happens. To bring some certain kind of transparency, fairness, 2013 Act has been brought into effect.
Yes.
And there are checks and balances under the Act. If somebody is not acting in accordance with law, you have all the rights to cancel, suspend. But why don't you give them their due, statutory due?
And when the involvement of central government is also there, they have.
Yes, central government, Mr. Bhattacharya. Why don't you oversee the aspect that your 13 Act has been implemented in? You can oversee, have the power under the 13 Act. 13 Act is your act, isn't it? National Food Security Act. So under that, this has brought to your knowledge, your notice by filing of this writ petition. You should oversee how is the state functioning so far as this implementation is done. You have said that you do not have much of a role, but the role to oversee, monitor, when more so when there is a grievance, specific grievance, that statutory requirement not met, not fulfilled.
20.
Mr. Mazumdar, you advise your client, the state, you resolve it.
Technical aspects are there, but
See, for the sake, we also know that for the sake of arguing, you will not make an argument. But if until there is something which is very substantial in nature, those can be taken care of.
only one aspect possibly needs your lordship verification. Presently, by a subsequent cabinet decision, it has been taken care of, they have been paid. Earlier, the decision to give a part of it to the GPSS, that is authorized agency, was pursuant to a cabinet decision of 30th of June 2021. Also, it is not on a challenge. And at the relevant point of time, that was not challenge possible. So that may possibly come in the way of the relief they are asking for.
But that was subsequently, that was modified.
Oh, yes.
So
that
when
was
subsequent,
modified to
subsequent.
Pay a certain amount.
That period is encompassing which, what is the tenure?
That my lord.
21, 22 onwards.
22 onwards, it's been done.
Yes, I'm not on that. I'm on the
Previous
Previous, but the previous payment, whatever my lord, that
was in accordance with the cabinet decision,
Yes.
not put to challenge.
Yes. Yeah, it requires your lordship.
No, Your Honor, I have no issue with the cabinet decision. Because what happens is that once the NFSA comes into enactment, the rules are enacted. There is one one circular that is passed, that is
Now,
20.
Mr. Das, if they fall back on a cabinet decision, which is not on challenge,
Because I'm not challenging it, Your Honor, because the cabinet decision only applies prospectively. So I'm not challenging the prospective application of because the cabinet decision, Your Honor, is actually very clear and I'm relying on it, the cabinet decision myself. Because it says after
or
threadbare.
you want to state that that will not come as a hindrance
No,
for you?
no, because they admit that the retrospectively what they were doing was erroneous. So that admission comes here. And this is only as far as the basic margin is concerned. As far as the additional margin is concerned, there's nothing, not a single rupee. For the completeness, Your Honor, the argument with regard to the additional margin is that it's been given to this someone called the system integrator.
System
Integrator. There is a provision, but it cannot all be given to the system integrator.
Mr. Mazumdar, come back with instructions. But I think how much time? 10 days time.
It will be 2 weeks.
But we're going to make some, so that it becomes easier for you to have the instructions. Heard Sri D. Das, learned counsel for the petitioner. Full stop. The grievance of the petitioner, which is an association, pertains to a claim emanating from the National Food Security Act 2013. Full stop. The specific case is that the rate of, what do you call this?
Basic margin.
The rate of basic margin, which has been specified, have not been paid to them, and there has been deduction from the prescribed rate. Full stop. It is contended that while rupees 143 is prescribed per quintal for the FPSDs, the state respondents have been deducting an amount of rupees 42.90.
Yes, yes.
90. And
For the periods of.
90 for distribution of food grains and paying the said amount to the Gram Panchayat Samabhay Samiti. Full stop. This court had considered the matter and issued notice pursuant to which pleadings have been exchanged. Full stop. Prior comma. The claim is directly connected to the statutory prescription and the deduction does not appear to be in accordance with law. Full stop. Though Sri D. Mazumdar learned AAG has cited that there was a cabinet decision dated
30th of January 2016.
30 January 2016,
16.
which was not put to challenge, Sri Das, the learned counsel for the petitioner, on the contrary, has submitted that such decision would rather come to the aid of the petitioners. Petitioner, put the para. In the petitioners, this court is of the opinion that the matter is one which can be very well resolved by the state on its own without the dispute required to be resolved by this court. Full stop. Para. Sri Mazumdar, the learned AG at this stage submits that some time may be granted to enable him to obtain appropriate instructions towards resolving, actual instructions so that the matter can be resolved. Full stop. Para. Matter accordingly stands adjourned to be listed on
11th, Your Honor.
2 weeks, 11th. Is it okay, Mr. Mazumdar?
Let it after, anytime after 15.
Then says 18th.
18th.
18th, Tuesday, 18th. You can place this if
Where?
it's required.
Your Honor, one mention may be made of the
20, 20.
20 is what? Okay,
Thursday.
Thursday. Okay,
Very well,
Thursday.
Your Honor. One mention of the additional margin also may be made.
Okay.
My submission that this, without challenging this cabinet decision of 30th of January 2016, they cannot get the relief.
We have already stated. We have stated. We have also recorded his submission that this cabinet decision, he says that will come to his aid. Let's see.
No, there are two cabinet decisions.
There are two cabinet decisions. One is of June 2021.
Okay.
Then,
On the net 16, which is not put to challenge.
yes.
On the other hand, Sri Das, the learned counsel for the petitioners, has submitted that there is a subsequent cabinet decision of the year 2021, which will
Yes,
come to the aid of the petitioners.
And one mention of the additional margin.
Our upor likhiba, grievance is also on the aspect of not following the statutory prescription regarding additional margin. Okay.
Deeply obliged.
ওপৰত এখানে তাৰ হেৰি যে আছিলে এমাউণ্টটো আছিলে তাৰপিছত এইটো ৰ'ব ফাৰ্ষ্ট পেৰাগ্ৰাফৰ লাষ্ট পালে ওকে yes next Ten yes.
Lordship, not there, but similar matter is fixed on 20th of August, Lordship. We have filed the affidavit in that case, Lordship. It is entirely similar, Lordship. Same tender.
Okay, none appears for the petitioner on call, whereas Sri Upadhyay, learned counsel, learned standing counsel. This is irrigation department is present, who submits that similar matters, including WPC,
4289 of 2025,
are fixed on
20th of August, Lordship.
20,
Lordship.
28 August, 28, 26. Para. Accordingly, matter is adjourned to be listed on
20th.
BSAF
Lordship. Obliged.
and Upadhyay. Reply file কৰিছে নেকি? On the request, I don't বিচাৰিছিল না এইটো? On the request of Ms. S.B. Chaudhary, learned counsel for the petitioner, matter is adjourned to be listed on Monday next. Monday না তেওঁ Friday বিচাৰিছিল. Friday বোলে, Friday কৰিলে. Item? PNRD, okay. Friday we had said. Infractuous. But in absence of the learned counsel, will it be proper? Or Friday, क्या बोला? No, sorry, Miss S.B. Chaudhary, learned counsel for the petitioner, prays for time, para. Miss P. Thapa, learned counsel representing the PNRD department, however, submits that the matter has become infructuous, para. Let this aspect be examined by the learned counsel for the petitioner and the matter be listed on Friday.
Pertains to renewal of armed license. We have already filed our affidavit. They have also filed reply.
Who is the petitioner?
Lordship, the matter may be deferred for today as my senior has left the court due to some medical emergency.
Okay, what do you do? What is the petitioner?
Lordship, petitioner is a political activist and businessman.
Political activist.
Yes.
Why do you
He
need?
contended
Contested in the Hazu LAC from 2000 in 2021 assembly election.
Why do you need arms license?
Lordship, he was attacked multiple times. We have given all the details in the affidavit in reply.
Some criminal cases are also pending, Lordship. That's why page 103 of our affidavit.
Why do you need time? Mr. Borwa, you sought time.
No, I have not. He stopped.
Okay.
So, Lordship,
You have filed affidavit.
We have filed our affidavit.
We
and
have filed
that's
reply
why
also,
rejoinder
Lordship.
also.
Pleadings have been exchanged. Full stop. A request for adjournment has been made on behalf of Sri J.I. Borbhuya. Full stop. Sri S.R. Borwa, London State Council is present. Para. Matter accordingly stands adjourned to be listed on 3rd of August. But you have to have a clear report on threat perception. Only making an FIR will not do. Whether those FIR had so many bases or not.
Yes.
And you have to make out a case that law and order has failed to protect you.
Because criminal antecedents are there. Police report.
Lordship,
clearly
mere
says that.
pendency.
Against him.
Yes,
Lordship, mere pendency is not a ground. Lordship.
one case is under.
So why do you need arm?
Most of the antecedents.
But why does the citizen need arm? There are police personnel, there is law and order to take care of you.
Lordship,
Has it failed?
Lordship, we were given PSO also once, but it was taken away. Now we are.
So why do you need a PSO?
Lordship, the petitioner was attacked. I was attacked multiple times. It is their own record, Your Honor. We have given in the reply, joinder.
Okay, let us examine.
Yes, Lordship.
Also cases are registered against him also.
Yes.
Yes, ma'am.
Lordship, may kindly take up the matter on next week. Next week, Your Lordship. May kindly
Next
take up-
week. Other side,
Already informed, Your Lordship.
Jorhat Municipal, Bhomik, okay. On a request made on behalf of the petitioner, matter is adjourned to be listed on Tuesday next,
Thursday, Your Lordship, 6th.
on 6th.
Interim order may be continued. Your Lordship.
Interim order passed earlier to continue till the next date of listing.
Obliged.
Your Lordship, basically, I'm assailing the tender cancellation process by the accepting authority of the railways, mainly on two grounds. One is that if this
Affidavits filed.
affidavit file pleading completed, Your Lordship.
We can have for admission hearing.
Yes, sir.
Well, matter of 26.
Yeah,
What is
look-
the, what is the present stage now?
There has been a stay, they have been restrained from giving a fresh tender.
We are not unable to, my lord.
Oh, there is urgency.
There is urgency, my lord, construction work, my lord.
Okay, we can have, you are ready, both of you are ready, we can have it. Yes.
My ground of accel is only two, Your Lordship. One is prejudice.
Yes, there was a NIT.
There was an
Oh,
NIT.
date of the NIT,
Date of the NIT is 11/12/2025,
page
page 39.
11/12/25 is a notice, NIT.
Yes, Your
So what
Lordship.
is the work about?
This was a protection work at minor bridge.
Protection work.
Yes. Page 40 gives the detail of the name of the work, Your Lordship.
Just a minute, please. 40.
40.
You had participated.
I participated with other bidders. Total six bidders were there.
6 bidders. Two bid system.
Two bid systems, technical and financial.
Okay.
Your Lordship may just in this context, when Your Lordship is there, may turn to also page 47 for one aspect, Your Lordship.
47.
47. There in this table, first table, bidding system, Your Lordship gets it. There is a bidding unit above, below, par. Basically, I have to give it in the percentage manner. And this bidding system,
Where is 47?
47 in the right hand side, fifth table, bidding unit.
Bidding unit, correct?
This is above, below, par.
Yes.
So it's basically I have to give, there is a schedule of rates of the railway. The rates are common. I have to basically say 18%, 12% below or above. That is the thing.
Or at par.
Or at par.
Okay.
Now, before I go to the other issue, here what has happened is that the financial bids were already open. I was the L1.
You were found to be technically responsive.
Technically,
how many found to be technically responsive?
5.
5. 5 found technically responsive. Your price bid was found to be the lowest.
Lowest. My
Petitioner L1.
L1, 18%. 18% minus
18% below.
Yes. 18.20% below.
Below, okay. Thereafter?
Now they have proceeded to cancel this tender. My basic contention, the way I will be.
Where is the cancellation order?
That, Your Lordship, if I may be just permitted, what has happened?
No, just place that order.
Yes, Your Lordship. That is at page 107 may be seen.
107. Discharge, tender is discharged.
Matter is this, sir.
Tender is discharged.
You're right, Your Lordship. This is the first decision. And then there's another decision of the tender accepting authority at page 114.
114. 114.
In the bottom, Your Lordship may see TCR accepted for discharge all items. This is dated 12/5/2026. 115 is the page number. These two decisions I have assailed it.
Okay. You were saying something before this discharge?
I'm saying that once the price bid is open and this is a fixed, already the rates are there, I have to quote basically above or par. and I have quoted my most competitive rate at -18%. The tender is now sought to be cancelled not only by way of bringing in about a new rate or new items of work. I'll show the grounds on which it has been sought to be cancelled. Now, even if they float a new tender, my rate is already open for everyone to know. And that on that ground, I'm submitting that I've been prejudiced.
Now, what are the reasons for cancelling?
That's where I'm coming, Your Lordship. Your Lordship may just first see page 90.
Page?
90. These are the, Your Lordship, in railway, first there is a technical committee who evaluates the technical bid, then submits its report to the accepting authority. Then the financial bids are open. Then the technical committee looks into the financial bid, gives their report, recommendation to the accepting authority. Then the accepting authority passes the necessary orders. Here, Your Lordship may see column page 90, column 2.2. This is dated 10/3/26, Your Lordship. The tender committee recommendation was submitted to the tender accepting authority on 10/3/2026. Decision by tender accepting authority. TCR returned to tender committee for review. Then remark by tender accepting authority. The technical eligibility warrants executed works of the nature of any tunnel work or major bridge work or protection work, including slope protection work using geosynthetic, geogrid steel cable.
Yes.
Then reinforced soil structure to protect hill slope. RE wall behind abutment will not be considered. / anchoring on steep slope stabilization work by shotcrete or RCC in mountainous region. The two works over which the credentials are claimed by Messrs. Pushpa's Construction Private Limited, that is me, do not fall in the mountainous region. These do not fulfill the technical eligibility criteria prescribed in the NIT of tender document. The criteria is primarily to select an executing agency accustomed with the present site, that is a hilly terrain. Please review the recommendation. Then review by tender committee. In compliance with so-and-so observation, the tender committee re-examined the eligibility. Finding. In view of advice of tender accepting authority, as above, TC has reviewed the eligibility of Messrs. Pushpa's Construction Private Limited as under. As per para so-and-so of NIT, the definition of similar nature of work includes the following. Any tunnel work or major bridge work or protection work, including slope protection using geosynthetic so-and-so. Hill protection air. Upon careful examination of the credentials submitted by Messrs. Pushpa's Private Limited, as detailed in para 6.23 above, and supported by the completion certificate, it is observed that the agency has successfully executed major bridge work. Since major bridge work is explicitly included as an independent qualifying category under the definition of similar nature of work in the NIT, the condition of execution in mountainous terrain is not applicable to this category. In view of the above, the tender committee concludes that the credentials submitted by so-and-so.
This is in your favor. Where is the decision?
This is in my favor. Then no, this will have relevancy. Because ultimately, when he goes again to cancel my thing, he says that since I do not meet this criteria.
Let us see where is the.
This I have shown, Your Lordship. Then Your Lordship will come to 13th page 107. This recommendation was given, technical committee accept that. Then Your Lordship may just first see page 106. Is that tender committee recommendation 7.3?
Yes.
It is recommended to accept the lowest valid offer made by the lowest tenderer, Messrs. Pushpa's Construction Private Limited. It is also recommended that the rates quoted in the tender schedule A so should not be taken so and so. Based on it, they recommend it. Then decision is given at 107 of the technical.
You come to the impugn part.
Yeah, this is one of the impugn, Your Lordship.
Which one?
This, page 107.
107, yes.
Decision, tender committee, TCR accepted for retender. TCR is tender committee recommendation for, they said for award, he has considered it as for retender. Then
What is
grounds-
what is the preceding discussion for this?
This, the tender is discharged with the remark. The tender condition for BOQ as well as EPC tender have been revised by Railway Board recently, and there is a significant change in that. That is the one. A presentation has been made recently regarding various flow protection measures and their durability. The efficacy and durability of the proposed work in the present tender needs to be critically reviewed and suitably revised. There is a confusing similar nature of work defining language in the eligibility criteria in the present tender. The desired agency should have adequate experience of slope protection work or soil stabilization work in mountainous region. Further tendering in this regard should be done as per revised tender condition circulated by Railway Board after arriving at suitable scheme of slope protection. This was again considered by the tender committee, and their recommendation again comes at page 112.
Yes.
Bottom, Your Lordship. The above remark of TAA, bottom 3 paragraph, have been examined and deliberated upon by the tender committee, and TC concluded that the TA has probably mistakenly read tender committee recommendation as retender. The TC has not given recommendation for retender but has submitted recommendation as under. It is recommended to accept the lowest valid offer made by the lowest tenderer for a total value of so and so. Moreover, tender accepting authority returned TC minutes without clicking appropriate decision option. TC has discussed and deliberated upon fresh observation of technical accepting of authority on first TCR, financial as under. The tender for the work was invited as per guidelines in vogue at the time of tendering. Hence, if any policy changes are notified issued by Railway Board in any condition, the same does not materially affect the instant tender unless Railway Board would have specified to revisit all tenders.
Mr. Senapati, these are okay. These are all in your favor. We want to see.
There.
Where
Then
is
in the end, that is at page 114.
114, yes.
Then he says, decision dated, that the first decision, 17/4/2026, page 107, of accepting authority so and so is already given that the tender is discharged. The planning of work as proposed is above discharged. Tenders should be threadbare review and put up for approval before going for fresh tender in this case. So the grounds on which the tender, the accepting office authority has sought to reject the tender, having been clarified by their expert technical committee, and no infirmity is there. My humble submission is that the decision of to go for discharge is arbitrary and without any rational basis.
What is the discussion which is discernible leading to the impugned decision?
The impugned decision of 12/5/26, he is not saying anything except by saying that follow the earlier decision of 17/5/2026.
17-4.
17/4/2026.
17-4, what is the discussion?
107, Your Lordship, may see. Only three grounds that there is a change by the Railway Board brought about which has no applicability. That
Mr. Gupta?
Basically, what has happened, my lord, the tender.
But once, see, you have a two-bid system.
My lord.
One is the responsiveness, technically.
Technical.
You have, hold them to be technically, hold him to be technically responsive,
Madam.
along with 5 others, 4 others.
Madam.
Out of 6, 1 is out, 5 are there.
Madam.
You go for opening the price bid. Price bid accepted, he found to be low, you are not aggrieved, you are not regarding the rate, it is abnormally low or high viability of the rates is not one of the reasons. You are going on again on the technical part regarding the work. Can you go back like this?
Well, the decision of the tender accepting authority is final.
No, no. Why did you first float the tender in the manner and you have accepted him to be technically responsive? Now, the only reason appearing that it's a slope or something hilly area, and that is the only reason. He has given his whatever his credentials. It was tested by a committee authorized in law,
So that
and there has been clarification also.
no tender committee can always clarify, but the final decision has to be taken by the tender accepting authority.
Accepting authority, but again, tender accepting authority to accept or not to accept,
Madam.
will have to assign reasons which appear to be reasonable.
So page 113, my lord,
Yes.
is the reason, my lord, which the tender committee has also discussed.
Where?
The first reason, my lord, is that the tender for the work was invited as per the guidelines in vogue at the time of tendering. Hence, if any policy changes are notified, issued by the railway board in any condition, the same does not materially affect the instant tender.
So this is in his favor.
I'm sorry.
113 is in his favor. See, matter was decided to be for going for discharge, which was again clarified that please do not misread our recommendation. We had recommended, not recommended for discharge.
No, but the,
Having said that, then again you fall back.
the requirement of
Why you don't like the petitioner?
no,
Maybe there are other persons who are more handsome than Mr. Sanapati.
no, that is not so, my lord,
It
because
appears so.
the nature of the work, it is the authorities, my lord, who has to satisfy themselves whether the
See, if the highest authority has the authority to defer, but to defer you have to cite reasons which appears to be genuine and bona fide.
no, regarding this,
There has been clarification also. It's not that somebody had arbitrarily chosen him.
no,
He passes through the first phase, technically responsive. In the financial, he competes, turns out to be the lowest bidder.
no.
You don't say that the bid is exceptionally low, so we don't give it to him. That is not your.
No, the
You can't go back to his technical expertise, which has already been said okay by the technical committee.
it was not said, okay, my lord, page
No, no.
10
How does he overcome the technical responsiveness then? It's a 2-bid system.
no,
He was held to be technically responsive. And technically responsive what? Vis-a-vis the work in question.
the tender authorities, my lord, they have to satisfy that the work which has to be completed, that should be, my lord, as per the criteria. They
There is
have
no,
the
there
authority
is no dispute to what you are saying.
No.
Accepting authority has the power, but power.
They can very well participate in the fresh tender, my lord.
Why should they? Then again, you will not have a person of your liking in the next. Again, go.
But, my
It
lord, we
appears
have to
so.
see the reasons, my lord, whether the reason.
You should have and the first threshold you should have said you are not technically fit.
No,
The tender committee says that if there is a policy change, that will not make any difference to a work which is already tender process is already started.
my lord, in page 107, my lord, the reason which has been given at point number 3.
Yes.
If my lord sees the original tender condition,
Yes. And see how 107 was clarified at 112. Come to 112.
no,
112 towards the bottom. The above remarks of the TA have been examined and deliberated upon by tender committee, and TC concluded that TA has probably mistakenly read tender committee recommendation as retender. all items. The TC has not given recommendation for retender, but has submitted recommendation under. Is reiterating the earlier recommendation in favor of the petitioner.
With this tag
Rather,
of-
we are not only giving it to the petitioner, we are on the aspect of bringing a logical conclusion.
No.
Whether the petitioner before was the L1 or somebody L1, we want to give it to the,
Not the tender accepting authority, in my humble submission, even at least, even if the tender condition does not specify any conditions. If my lord, the authorities come to know, my lord, that there is some confusion as to the qualification, they may not discharge it and clarify it in a fresh tender process. Because ultimately it relates to the work to be performed by the contractor. If my lord, if I may read just
so why do you go by a tender process? Tender committee, whoever they think they are the best judge, you are the best. Why having different committees to evaluate technical responsiveness, to evaluate financial responsiveness? Why needed?
No, but the reason
It's max of arbitrary power, arbitrary exercise of powers.
The reasons for that, the reasons have to be held to be arbitrary, my lord.
Yes,
That has
appears to be arbitrary.
My lord,
And that too after reiteration.
my lord.
We thought that there isn't a reiteration that maybe you have misread our recommendation as retender.
But if I may read just, my lord, page 107, clause 3, the reasons, that is the main reason, my lord. The other two reasons perhaps may not be that important. There is confusing similar nature of work, defining language.
Where are you reading?
Page 107.
Decision.
Decision.
Yes. Tender is discharged with the remarks.
Yes, my lord.
Hmm.
There is a confusing similar nature of work, defining language in the eligibility criteria in the present tender. The desired agency should have adequate experience of slope protection works or soil stabilization works in the mountainous regions. Further, the tendering in this regard should be done as per the revised tender condition circulated by the railway board after arriving at suitable scheme of slope protection. That was not there in the tender condition, my lord. That is why the authorities have discharged it and they want to now incorporate the provisions for slope protection, my lord, in the eligibility criteria.
Now you have
That's a technical requirement, my lord.
now you have one party who has had the experience of having a constructed bridge, and those have been taken into consideration by the committee. Have you seen those observations?
That is what, my lord, my lord, page 43, my lord, see, the similar nature of work is defined there.
Yes.
My lord, and if I may read, not any tunnel work or major bridge work or protection work,
They
including.
have done two major bridges.
Yes, my lord. That will not, my lord, fulfill the criteria of the slope, my lord.
Only because
the slope
somebody thinks
protection.
later on.
My lord.
Only because somebody thinks later on.
No, my lord, it is there, my lord, but these conditions are not clear in the, my lord, definition of
So
similar.
you call for tender for a specific work for which you evaluate the technical responsiveness, whether its party is technically qualified to be given such a work or to compete for such a work. Work has been defined already. It has slopes, it has got tunnels, it has got this.
No.
Having said that, and you have also said that you need to have major bricks work. They have done two bridges, major bridges.
No, regarding
And
the slope
more than
protection-
that, an expert body of of doing a technical evaluation, they have found the petitioner to be technically qualified along with 4 others.
No, regarding the slope protection measure and durability, the tender accepting authority has come to a conclusion that there is a, my lord, revised railway board guidelines to that effect.
That is not applicable.
That is why, my lord, there is a need for the fresh tender. Because that page 107, my lord, with regard to that slope protection measure and durability, there is a revised railway guideline by the railway board, my lord, by which there is a direction to the authorities, my lord, to ensure, my lord, that the slope protection measures and durability, my lord, that is.
Where is it? Let us see. Where is it?
Page 107.
No, that we have seen. Where is the revised protection, revised scheme?
You know, that my lord, I have to take instruction.
No, 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 you have filed your affidavit.
Revised railway board.
Definitely you must have
There.
had in your affidavit. That is your only, if you are falling back on that, you have to.
In the affidavit, we have stated, my lord, but that railway board circular, my lord, we have not annexed, my lord, that I may not take instruction to.
That is what, if at all,
That's
you are
that
in.
we have stated, my lord, in paragraph 12.
No, that, see, that you have to state otherwise also. That is the reason you are taking aid of.
That is specifically towards.
Aid of, so we need
Yes.
to have that in your affidavit, but we need to see what are the railway board revised guidelines.
Yes, my lord, that my lord, I'll take instruction, I will produce that specific circular by which only with regard to the slope of work, my lord, that direction was there. Otherwise, my lord.
Circular came when?
Annexure 4 and 5, Your Lordship.
You have the circular,
Yes, so in the writ petition, we enclosed it.
page?
Page 111. 116. The first one is with regard to EPC tender document only. And in para 2, it is saying with prospective effect. This is after the issuance of the tender.
Hmm. This is what you are falling back upon, Mr. Gupta.
This is the, and the next-
116? Is it 116 only or anything else?
To take instruction, my lord.
and the other one is at page 130.
130?
Yes, Your Lordship. This is with regard to work contract. In para 2, it says with prospective effect. And in the affidavit, they have nowhere said that there is a railway board circular with regard to protection. No. And Your Lordship, may just in writ petition, if Your Lordship may just come to the final comment at page 113.
Just a minute, please.
113.
Just a minute. Yes, Mr.
With regard to similar
Page,
nature, page 113, Your Lordship.
113.
I'm just reading the tender committee recommendation.
Yes.
Serial number 3, Your Lordship got it?
Hmm.
The definition of similar nature of work for eligibility criteria was approved by the competent authority, who is also PAA in present case, in e-office so-and-so, status as document title so-and-so. Moreover, though not relevant in present case, from the records available in the bid capacity document, page number 3, serial number 16, attached with offer, bid capacity attached, the lowest valid eligible tenderer has worked in mountainous region in so-and-so area. In view of the above, there is no valid ground to revisit the present tender after opening of its financial bid. Tender committee therefore again submit as under. Then with regard to slope protection, paragraph number, point number 2. The presentation was made by the agency and protection work proposed for breach numbers 164 was discussed. The said discussion was not related or referred or verbatim applicable to the section where the breach protection work is to be executed in present work. The drawing for the protection work in present tenders are already submitted to CBA NFR and are in advanced stage of approval. If any changes are required, then the same can be appropriately incorporated at any later stage. The planning of protection work
as per present tender was discussed during recently concluded CRS inspection, and the scheme of work are largely accepted. And it was emphasized that protection work as in present needed to be completed at the earliest so as to safely cover the monsoon months. So for the
Mr. Gupta, both the reasons or which the tender committee, accepting committee has cited, both appears to be faulty, factually also and legally also. Those new policy has to be applied prospectively. And apart from this observation that he has experience in working in terrain, the requirement was that he should do similar nature of work, and to his credit, there are works of two major bridges.
That is all, that is acceptable. My only contention is that, as per the railway board circular.
Circular is prospective in nature.
The suitable scheme for slope,
Is it prospective in nature?
was not there, my lord, under the tender condition that the authorities now want, that they want to modify.
So how do you overcome the prospectiveness? 13/3 to 2026, both.
Regarding
116.
that, may I take, my lord, instruction?
What
Because
instruction
I
is
don't
written
have,
there, prospective?
regarding the railway board circular, which, my lord,
Aren't this circular at 116 and 130?
I have doubt, my lord. I will take instruction, my lord. Which circular they are referring to, my lord? If my lord is not satisfied with that, my lord, can.
No, it's not a question of we not being satisfied. It's a question of applying the law. This is the railway board circular of latest 13/3/2020.
Specifically regarding suitable scheme of slope protection, that all tender conditions should have that scheme, which was not there, my lord, in the present tender condition.
Yeah, it's there.
That-
111, your lordship may say that's work.
And the definition of similar nature of
No,
work, my
it's-
lord, does not fulfill that.
No, similar
criteria.
nature
That
of
is
work,
what the authorities have.
any tunnel work, major bridge or protection work,
Including slope protection.
including slope protection. It is there. They themselves have provided three alternatives.
So Gupta, you don't have.
Not had there been no reason at all, my lord, here reasons are there, my lord. And those reasons, my lord, in my humble submission, it is for the authorities to, my lord, assess the requirement of the work. And, my lord, the tender accepting
So Gupta,
authority.
the
Because
decision,
we also don't, my lord.
the disqualification is not by the technical committee.
Not a
It had gone much ahead. And the reasons which you are prescribing appears apparently to be in conflict with your own circulars and your own requirement. Three requirements that any tunnel work, any major bridge, protection work including slope, or for protection work, you say protection work, the slope work, there is another circular. Circular comes into effect prospectively.
Only tendering accepting authority, my lord, in the last line of page 107 has stated that tendering in this regard.
That is
should
why
be done
judicial
as-
review is there.
My lord,
For that
No,
reason, we are exercising powers of judicial review.
as per revised tender conditions circulated by railway board, my lord, that circular. May I
Aren't
be-
this the circular 13/3?
that I have to take instruction, that is why, my lord, I am submitting. If that, my lord, I can just produce that circular. If
When can
that
you do?
requires,
When can you do?
my lord,
When can you do?
lord, on 5th, my lord. I am not available, my lord, from
Not 5th, we'll have it on 4th.
4th, my lord, I will not available. 5th, my lord.
Okay, 5th. 5th.
Your lordship, can it be, I'm sorry, your lordship, can it be on 7th, your lordship? The matter is already heard, only on this issue.
7th, 7th.
Then 11th, your lordship.
No, we can try on 7th.
7th, your lordship, we'll try it.
Okay, so Hertz Free D. Senapati, learned counsel for the petitioner, who is aggrieved by the decision for discharging the tender in which the petitioner was not only found to be technically responsive, but also found to be the L1, full stop. The petitioner also relies upon the recommendation made in his favor and subsequent clarification made to clarify that subsequent clarification made full stop. It is also contended that the impugned decision is based on irrelevant and extraneous consideration, irrelevant and extraneous factors. Full stop. It is also submitted that though new guidelines of the radio board has been taken recourse to for passing the impugned order, for taking the impugned decision, the learned counsel has submitted that the circular itself makes it clear that the same would come into operation prospectively. Full stop. Para. At this juncture, Sri H. Gupta, learned CGC, appearing for the railways, pray for some time to obtain instructions regarding the new guidelines of the railway board. Full stop. Para. Since the guidelines have been enclosed to the writ petition, both dated 13/3/2026. Correct? 13/3, specific instructions are required to be taken by Sri Gupta, the learned CGC. List on request, list on 11.
Yes, Your Lordship.
Not 11, 7th.
7th.
of August 2026. Interim order passed earlier to continue till the next day of listing. A corporate instruction will try to have this matter disposed of.
I'll make it short as possible.
You have to, because the brief is,
That's why I know.
papers are very bulky, so.
I'll make it short as possible.
Yes.
My lord,
What
just to
is,
start.
you're a JV,
Yes.
you're a JV, joint venture.
My
A
lord,
grievance?
yes, my lord, to open the particular case is regarding an improvement and upgradation of roads in the BTC area. And it's under Mala project. A tender was floated. We participated along one of the private respondent.
It's a hop.
Yes, technically both qualified, but financial bid, we were not aware when the financial bid. We came to know from the office that the financial bid were open. Then we represented, we given a legal notice, and we said that technically they should not have qualified. The private party of Mr. Hawk. He should not be technically qualified on two grounds. That's a particular ground which we have brought notice to this court. One ground, my lord, 4.3H. 4.3H says the report of the financial standing of the bidders, namely the profit and loss accounts and the auditor report for the last 5 years has to be submitted. This is one of the 4.3H, which Mr. Hawk's client has not annexed two of the terms. Only 3 terms has been given by him, and that too also incomplete. So we say that's a mandatory clause. You cannot. This is number 1, my lord. Number 2 is 4.7.
How did you come to know that he has not fulfilled?
Because all this is uploaded technical online.
Okay, you could see.
Online, we can, yes.
Okay.
So, my lord, we came to know that. And 4.7.
What is the response of the
now BTC
authority?
response? The BTC response is that no, what we have done, my lord, they have to test of responsiveness has to be basis on this. They said no, that's not the criteria. My primary material which we have considered is not on that 5 years. We considered on the basis of the single certificate and the
and the certificate, turnover certificate, turnover certificate, turnover certificate, because financial, what report, why they want the report 4.3H, report of the financial statement of the bidders, they want to see what is the profit and loss and auditor's report. That's the main. What is the financial standing of the parties? Now, they said this is not the criteria. Our criteria, they have assessed on a different way they have assessed. Now, our whole case, whether you can, my lord, the terms and condition which you have set, whether on that parameters, you have to look into it. You cannot look into other parameters. You cannot look into other parameters. That will actually be hit by judgment of the Supreme Court. Once your terms and condition has been laid down, it should be equal to all the bidders. There were two bidders in this case. There were no third bidder, two bidders. Myself and Mr. Hawksland. There were two bidders. So first point, if your lordship looks into 4.3H and 4.7 has to be liquidated, false and misrepresentation in his bid. If that be the case, entire bid should be rejected. That's the point, my lord. See, normally the law which is settled is that the authorities would be the best judge to interpret. But if you can make out a case that there are mandatory requirements which the private respondent has not been able to fulfill, and only taking advantage of the fact that I being the authority, I can. If it's mandatory in nature, then you may have a case. But if we find that they have substantially met the requirement.
Yes, I will just, this is the case, my lord. I can project the case and what is my case, how we built up the case, and what is.
Otherwise, what is your price difference?
Price difference, I am not, 50 lakhs.
We are not aware about them.
What is the value of the contract?
Value of the contract?
50 crores.
Yes.
23 crores. Your price is less by 50 lakhs.
50 lakhs plus,
50 lakhs.
yes.
Okay.
But my lord, the law is now NG Projects, Monte Carlo, NG Projects says technical bid will not be looked into by the court. It is only they will assess on the basis. But now it has been changed. Bangshidhar also says, by the end of the day, if the contract has been awarded, technically one is not qualified, your lordship is aware of, then also it can be set aside. How they have assessed? My lord, if the mandatory clause they have set up, a mandatory clause, that cannot be applicable to one of the bidder. It has to be equally applied. By their own statement, my lord, I will show that the assessment made by them is totally different. Whether that is the first point, whether they can look into it or not, in a different way. Not on the basis of the term which they have set out under 4.3H.
Let us first see the terms.
Please see.
Which you allege that private respondent has not been able to.
Writ petition, my lord.
Yes.
Well, I'll directly take to page 43.
What is the present stage? Is there an interim order?
No, there is an interim order.
So work is not been done.
Correct. Please see 43. Work order issue.
43.
43, my lord, will look into first. 43. Affidavit block ulai rakhi ekaloge dekhai din. Page 43, my lord, 4.3H. 4.3H. 4.2 is the pre-qualification condition and 4.3 is all bidders shall furnish. Please, my lord, shall furnish the following information section 2. If you see straight, 4.3H, my lord.
Yes.
Reports on the financial standing of the bidder, such as profit and loss statement and auditor's report for the past 5 years. Lordship got it, my lord?
Yes, yes.
Now, if you see at page 55, please for a moment, please see page 55. Immediately your lordship will look into page 55. 55. I'll just connect to page, the clause 40, page 43. My lord, examination of bids at clause 26.
Yes.
Examination of bids and determination of responsiveness. Now, if you see that during the detailed evaluation of technical bids, the employer will determine whether each meets the eligibility criteria defined in clause 3 and 4. Lordship got it, man? Now,
Yes.
see at page 43, clause 4 is qualification of the bidder.
Yes.
Qualification of the bidder.
Hmm.
So you have to test of responsiveness, which they have laid down as a mandatory, shall furnish 4.3H is on the report on the financial standing of the bidders. Profit and loss statements and auditor report for the first 5 years. That's the first point, my lord. Petition move. Now, more statement report said. My statement 84.3H.
Mr.
Now,
Hawk, your response number? R4. R4 does not meet, Mr. Das?
I'm sorry.
R4 does not have the auditor report.
They doesn't have all four. Read, please, let me say whether. No, don't
Auditor
say
report is
now.
there or not?
They doesn't have that profit and loss statements or the balance of the auditor's reports in not all the 5 years.
Not 5 years.
Not 5 years. Profit and loss statements, my lord, they doesn't have. All the profit and loss statement and auditor's report they doesn't have for the last 5 years. 3 years, yes, they have. 2 years, they have not submitted. That's my case. 3 years also, it is also incomplete. That's my case, my lord. Let them show. They will have a turn to show. They have all the 5 years, then I will be out on this point. That's the main point, my lord, 4.3H. And apparently, I'll show. Now, my lord will kindly see. My lord, please see paragraph 9 of the writ petition at page 10. How I dealt 4.3H, my lord. Please see page 10, paragraph 9, how it has been dealt by the writ petition on 4.3. 4.3 at page 9. Paragraph 9, my lord. Page 10. I just read this, my lord. That as regard non-fulfillment of mandatory pre-qualification condition by respondent number 4, the petitioner humbly state pre-qualification conditions are mentioned in clause 4.2 and 4.3 of the instruction to bidder, section 1 of the bid document. As per clause 4.3H, all bidders shall furnish the following. The report so and so. Thus, it is mandatory qualification requirement that bidders must furnish financial report such as profit and loss statement and auditor's report for the past 5 years, the affidavit 2 letter. However, the respondent number 4 failed to furnish, Lordship got it?
Yes, yes.
Failed to furnish the financial report for the financial year 2024-25 and financial year I have mentioned 2021-22. The respondent number 4 has furnished incomplete financial report for 3 out of past 5 years and for remaining 2 years, financial year 2024-25 and financial year 2021-22. Respondent number 4 did not furnish any document pertaining to financial report such as auditor report, profit and loss statement, balance sheet and income tax return. Such omission renders the bid non-responsive. As such, the respondent number 4 failed to meet the mandatory qualification requirement. Hence, his technical bid is liable to be rejected. Now, my lord will kindly see, my lord, how it has been dealt by. I'll straight away, my lord. Then I will show the profit and loss, and I will show how I have bought that profit and loss statement, balance sheet, auditor report. It is mandatory. Now, please see at 570 the statement of the BTC, my lord.
But how did the authority evaluate or assess the financial capability of the respondent number 4?
Now,
see, the requirement is to be satisfied on the financial standing. The expressions used in 4H is illustrative in nature.
Yes.
They have used the expression such as.
Yes.
Such as the reports on the financial standing of the bidder. How do you evaluate financial standing? Such as maybe financial profit and loss statements and auditor's report for the past 5 years. There is slight ambiguity in this. How do you construe this?
Yes.
Requirement is to have that may be a profit and loss account, a statement or auditor's report for the past 5 years, which will be enough to understand their financial strength. Now,
Such as my respectful submission before your lordship is that whenever financial statement of the bidders is such as, you will find out from profit and loss statement and auditor's report. Otherwise, that particular, the words such as would not have been given.
no,
Only
we
annual-
have come
No, I-
across many clauses
Yes.
directly requiring you need to give 5 years of profit and loss. You need to have a certified auditor's report. Here, you have said you need to have their financial strength evaluated. How do you do it? By such as by a profit or loss account.
No.
How much that will be binding? That is one
That's what
point where you have to.
Now I'll show it before then. What is a stand taken by the BTC?
Correct.
State that it will be easier for. Then I'll show it. Please see page 570 of paragraph 14 of the BTC. How dealt my statement in this case?
570.
570 at paragraph 14. Please see paragraph 14.
Yes, please.
That with regard to para 9.
Nine.
Para 9.
Yes.
Of the writ petition, the answering deponent state, respondent for has submitted chartered accountant turnover certificate having UDN number so and so for the financial year 2020-21, 21-22, 22-23, 23-24, 24-25, dated 11/6/2025. Right, man? The CA certificate is a professional certification, and the CA is a statutory authority under the Chartered Account Act 1949. The certificate bears a valid UDN unique document identification number, which is an additional safeguard against forgery. The certificate consolidates turnover for all 5 financial years and therefore constitute valid compliance with the financial documents requirement. Now please turn. Now, if your lordship, for a moment, now I will just two line for a moment. I will pause for a moment and trouble. Let's finish it. The Tender Evaluation Committee considers CA turnover certificate as a primary document for evidence. Now, CA's turnover certificate as the primary documentation for evidence. So 4.3H. Now, your lordship has put a question to me that what do you mean by that? Such as, maybe not a mandatory clause. But please see now for a moment in this connection, I will show your lordship page 453.
453.
453. Oh, right.
What is 453?
453. These are the, my lord, please see. These are the bid document of R4. Lordship, please see 426. It starts the bid document.
426.
426 it starts.
Okay.
And if you see at 453, Lordship will find the chartered accountants certificates.
Yes.
Now, Lordship got it, my lord?
Yes, yes.
One second, my lord. Just give me for a moment. Just for a moment, my lord.
Yes, yes. Take your time.
Auditors report.
That will the what report on the financial standing. So financial standing cannot be only turnover.
My lord, kindly see at page 43, 453. 453, Lordship got it?
Yes.
Please see chartered account certificates.
Yes.
These two certified as per balance sheet, contract and profit loss as produced by me, by so and so. Total amount turnover of the civil engineering civil contract last 5 financial year. Now, if you see the financial year 2021 and 2020 and 21 is shown the figure on the right hand side. And if you see 21, 22, figure has been shown. But there is no verification, no documents, which is required to show profit and loss statement and auditor's report. If you see 4.3H, please look into the.
This is a mere turnover certificate.
This is only a turnover certificate, my lord.
Cannot clear as a report.
These are only turnover certificate, my lord. It is not a report. Please see 4.3H at page 43, my lord. 43. Reports on the financial standing of the bidder, such as profit and loss statements and auditor's report for the first 5 years. This is only, my lord, is a certificate which is given.
Turnover.
Only for turnover. Please look into it, turnover.
Sales.
But that cannot be a ground with greatest respect, my lord. Because their whole case is based on this. My lord, we see that tender will consider CA turnover certificate as a primary document for evaluation. With greatest respect, my lord, how they can rely on CA turnover certificate. Now, my lord, quick, my lord, to look into it, my particular 598, please see, my lord. Immediately to this, how do we respond to it? 598.
Up.
598.
Please, how I respond to it, 598. I'm just connecting it to my lord so that it becomes 598. How I replied?
Yes.
598, paragraph 4. What you got it?
Yes, please.
As regards the statement made in paragraph 14, 24 and 25, the affidavit in opposition, deponent respectfully submits that the Reliance pays response number 3 upon the chartered accountant turnover certificate dated 11/6/2025 is wholly misconceived, legally untenable, and contrary to the express term of the bid document. It is submitted. Clause 4.3H of the instruction to bidder unequivocally mandates submission of audited financial statement, including profit and loss account, auditor's report for the last 5 financial years. The said requirement is mandatory in nature and cannot be substituted, diluted, or overridden by a consolidated certificate issued by the chartered accountant. The attempt of the respondent number 3 to elevate the CA's turnover certificate to the status of a primary document is arbitrary, dehones the binding condition, and amounts to rewriting the terms of the tender, which is impermissible in law. Tendering authority is bound by the conditions stipulated in the bid document and cannot introduce new criteria or relax mandatory requirement in favor of any bidder. Now, the writ petition further states it is a settled principle of law, terms of a tender are sacrosanct and must be adhered to strictly. Respondent number authority cannot dilute, waive, or substitute mandatory condition in favor of any. So, my lord, few of the judgments were quoted, my lord, Epcons and Michigan, and thereafter at page 600, if a lordship turn to page 600, last 5 lines. Thus, the attempt of the respondent number 3 to treat a consular CA certificate as a primary document amounts to an impermissible alteration of the tender condition and is therefore arbitrary, illegal, and violative of article of the Constitution of India. So that is the first ground we have taken and we responded, because ultimately private respondent, the main is how they have, my lord, they looked into how they have, my lord, looked into the terms and conditions. That's why I don't want to give a response to the private respondent in this particular issue, my lord. Regarding the analysis will be done by BTC, my lord. That's why I have given a reply, my lord, on this. Now, my lord, I will show, please, I will show how the document they have submitted. If your lordship see it from page 426, please see the documents of the private respondent, number 4. If you see 426, my lord, it starts the bidding document of respondent number 4. Now, if you see 490,
494.
494, 494,
494.
yes.
Yes.
My lord, 494 is the assessment year 2021-22. If your lordship.
Of
can-
the response number 4.
Yes,
Financial year.
financial year is 2020-21. And it will be the assessment year will be 2021-22. In the right hand side of the column, my lord.
IT return of
IT
R4,
return.
R4.
Yes, correct.
The IT return, that's the acknowledgement.
Acknowledgement. Please see the acknowledgement.
Yes.
One second. Now, your lordship got it?
Yes.
Now,
Acknowledgement, not the entire.
this is not the entire, this is only the acknowledgement. This is only the acknowledgement. Please see 495 now. This is a balance sheet. Lordship got it?
Yes.
Balance sheet. 496 is a profit and loss account. At 496. And 497 497, 98, it is schedule of the balance sheet. Now please mark, there is no auditor's report. Here there is no auditor's report. It is, here you find the 4.3H, if you read it, my lord, profit and loss statement account and auditor's report for the last 5 years. So please note, my lord, there is no auditor report so far as 2021-22, the assessment year. Financial year is 2020 and 21.
It's the beginning year.
That's the beginning, my lord, of the year, for the last 5 years. Now, this is auditor's report is not been annexed, so this is incomplete.
So the CS certificate 430, 453, what is that?
Yes.
Which you have shown?
453,
Yes.
that is a turnover certificate. Only for turnover, please look into it. At 453 is a turnover certificate. This is a turnover certificate, my lord.
Yes.
Lord, you got it, my lord?
Yes.
Turnover. Now this is, I will take to next, my lord. 21-22, my lord.
Not a single document.
Not in a single document they have annexed. 21 and 22. 21-20, which I have mentioned in paragraph 14 of my writ petition, my lord. 21, paragraph 14 of my writ petition, the specific averment has been made. Lordship can note down 2021-22, no reports, no documents submitted. 21 and 22, my lord. Now next, 2022-23. Now if your lordship looks at 484, this is 483, it starts. 483. এখন কি হয়? কি হয় 483 হয়?
Form 3CD.
কি হবে?
It was income tax.
This is about income tax, my lord, 483. Form number 3CD. Lordship got it?
Single page.
Only a single page,
Not the entire set.
not the enter set. Part A, we find it. Lordship got it? Yes. Now please turn to 484. Is a balance sheet. They have come up on 31st March 2023. And profit and loss is 485. Lordship got it? 485.
Yes.
Profit and loss. And 486 is the schedule.
Again, no return.
Schedule. No, this is partly and no auditor's report. IT return, auditor's report not been furnished.
Financial year is 2023-24. That's it, perfect.
Now, next, 23-24, which your lordship will find at page 455. 455 is the acknowledgement, IT return. Please see the income tax return acknowledgement. Assessment is 24-25, but financial year is 2023-24. Now here your lordship will find.
Just a part of the for income tax purpose only.
No, but whatever.
But clause 5 of form 3C.
Man, please see 456. This is chartered accountant. Refer clause 5 to form 3CB. He has given a note to the report forming part of a auditor's report. Now, this auditor report is they have.
But they have not furnished.
Auditor's report. That's why notes to a report forming part of auditor's report.
Only a single page notice.
Only single page.
Notice given. Entire auditor's report.
Yes. Otherwise, the auditor report should not have been mentioned in 4.3H. Rose, we got it, Milo?
Yes.
Now, please turn to 457. 457 is a profit and loss statement. 457. 458 also balance sheet up to 458 to 463, my lord. My lordship can just note down 458 to 463 is the balance sheet. This is what, my lord. Now, last 2024-25, that's a financial year, we find that there is no document which have been submitted. That's why specific averment has been taken.
For which year?
24-25. 24-25.
This is your specific pleaded case.
Yeah, paragraph 14 of the writ petition. Paragraph 9 of the writ petition, which I read, my lord, which the BTC responded in paragraph 14, right?
Yes. And we again responded in paragraph.
Again, we respond in paragraph
4 of the affidavit.
4 of the affidavit in reply. And their specific plea, stand your lordship is saying their primary material they have assessed in the base
Mr.
of.
Bhuya, you have got the records.
Yes, we have got the records, my lord. Record will speak in everything, my lord. The truth with regard to this, these are
Okay.
allegations.
Today we may not, we can continue day after tomorrow.
I'm there. No
Day
problem.
after tomorrow?
Absolutely fine.
But we'll complete your argument day after tomorrow, then we'll hear Mr. Bhuya.
Yes, sir. No
But
problem.
more on the aspect of the records. And we want to see how they have arrived at the satisfaction regarding the soundness, financial soundness of
Yes.
the respondent number 4.
Right.
And you can place the relevant case law, Mr.
Yes,
Das. You can place the relevant case laws.
Yes.
Which holding the field,
Yes, I will show.
the scope of judicial review.
Yes, of course.
And regarding they being the best judge, in
No,
spite of that, if a decision is taken arbitrarily or without taking into consideration the relevant factors,
Relevant factors.
then
yes.
or some extraneous factors playing a role in the decision-making process,
Yes, I will show.
then there can be a scope for interfering.
Yes.
Yes.
Otherwise, matter of public importance
Yes.
is the construction of a what?
scope
Construction of a road.
yes,
Upgrade.
my
Yes,
lord,
my lord.
scope of judicial review up to we understand up to Galaxy, Monte Carlo, NG project must be different. Now,
NG is on a different context. NG is after this amendment of the specific relief act.
No,
On those
my lord,
later on,
but I know
NG has been
that paragraph, but now what is said, the role to decide about a technical bit is the hands of the authority concerned. Technical bit, they are the best just to decide.
even
but-
in Central Coal and Silpi.
yes.
Central Coal, Silpi.
But you, if you,
It is not the case
what
on the
is your
petition
case? My
that
lord,
he has been disqualified.
no. What,
Both have passed the technical route.
they did
And
not
with
pass.
regard to decision-making process, it's the authority whether any biasness or arbitrariness is there. And if your lordship peruse the records and come to a finding.
Mr. Bhuya, you have to point out one thing.
Yes, ma'am.
At what stage the challenge has been instituted?
Yes, ma'am.
If the challenge has been instituted, not
After-
immediately,
Yes.
having known that they have also been held to be technically qualified,
My lord.
that point the challenge should have
Taken
come.
qualified, yes.
When has the challenge come? Has it come
The
belatedly?
decision-making process is over and they know.
Then
No.
then there might be a.
No, we have,
Before financial bid.
before financial bid, we have given a legal notice thereafter. I will satisfy your lordship when we came. When we came, will satisfy. And how we were not informed of the financial bid on the face of it, I'll.
This may be relevant, but see,
Yeah.
there are situations where a bidder's technical bid is held to be non-responsive. He becomes aggrieved, comes to the court.
Yes.
Here is a different case slightly.
Yes.
You are aggrieved by holding him to be qualified.
Yes.
Correct, right.
Yes.
That's the point.
So in that case, when you have come to the court will be a relevant
That's it. Yeah.
consideration.
It's open on 35 and they have come on 4/6 after opening of the financial. That's a better record.
No. They have not informed us about the financial bid opening. Only after filing of the case, we came to know the financial.
We will consider everything. Day after tomorrow, can we have day after tomorrow?
Yes.
Yes, ma'am.
Okay. Third, Sri D. Das Learned Senior Counsel assisted by Sri P.R. Sharma.
PK, sir.
P.K. Sharma. Also heard Sri A.K. Bhuyan Learned Senior Counsel for the BTC assisted by N.R. Sharma, as well as Sri S. Hawk Learned Counsel for the prior respondent number 4. Paucity of time did not permit the matter to be taken up in its entirety. List on Thursday.
Okay.
The learned the records may be kept. Records may be kept. May be made available. Other matters will have some other day. No time. লগাই থৈ দিয়া তো লাগিবই চোন
Item 21 is date.
21. 21. What was the matter? Oh, it's an old matter. Oh, Mr. Mohanto was there. Yes. What was it? Applicability of 1964.
Yes.
What some instructions?
This was pertains to disciplinary proceeding and reference was made to the labor code and that.
Well, no, we'll not hear it today. We'll have it on Tuesday next. Tuesday next to deliver. আর এইখানে এই মাত্র কেস টু